ruling that the Jackson Women's Health Organization wouldn't be penalized for failure to follow the new law requiring admitting privileges for doctors who perform abortions. The state of Mississippi nonetheless moved ahead with its efforts to shut down the clinic. Soon after the judge's order, the state made its initial inspection of the clinic to cite it for noncompliance with House Bill 1390. The year 2013 began with the board informing the clinic that due to its noncompliance with the new law, its license would be revoked, a potentially multi-month process that is currently underway and will undeniably bring all parties once more before the courts before it is completed. Although abortion in Mississippi technically remains a legal right, access to the procedure hangs by a thread.
I inquire my fellow guy.
I would gladly yield the floor to my sister.
All right. As we start to see the sunrise, I'm going to attempt to go off of that for my light source. I am back up. My name is Maisie, and I drove to this filibuster from Des Moines, Iowa, because I feel that it is so important to hold politicians accountable for the inappropriate medical decisions that they attempt to make. So I will continue reading where Sue left off from the wonderful Crow After Row. And we're going to be going into Chapter 12, titled Arizona, Banning Everything But the Kitchen Sink. When Jan Brewer, a Republican, replaced Janet Napolitano, a Democrat, as governor in 2009, the residents of Arizona were quick to learn how important a gubernatorial veto can be when it comes to protecting the reproductive rights of women in a state. Brewer, the former Arizona Secretary of State, took over when Napolitano was selected by President Obama to be the new Secretary of Homeland Security. The move may have improved the safety of Americans across the country, but women in Arizona were left vulnerable to a state legislature determined to undermine their right to a safe legal abortion, birth control, and other reproductive services. Emboldened by the knowledge that any anti-abortion bill they passed would now automatically receive the governor's signature, conservative politicians in the Arizona legislature went to work on anti-abortion omnibus bill that Rachel Gold and Elizabeth Nash of the Guttmacher Institute said essentially revamped abortion policy in the state. House Bill 2564 added a 24-hour waiting period after mandatory counseling from a doctor prior to an abortion, extended the ability for providers to invoke a conscience clause, and added restrictions for teens trying to obtain an abortion. That was only the beginning. Since that 2009 legislative session, Arizona lawmakers have proposed a myriad of laws designed to coerce women out of having abortions via methods such as insurance coverage bans and alterations to the tax code so that donations to groups that provide, refer, or even mention abortion can no longer be tax deductible. In 2011, the state passed House Bill 2443, the Prenatal Non-Discrimination Act, PRENDA, a race and gender-based abortion ban that made it a felony for a doctor to perform an abortion on a woman choosing to terminate her pregnancy because of the race or gender of the fetus. While the ban itself was mostly toothless, how exactly would one be able to know the motive of a woman terminating a pregnancy unless she told the provider in the first place? The idea behind the ban was to make doctors nervous about potential liabilities for abortions they performed, as well as to throw up an additional hurdle for women of color seeking an abortion. For women who already had limited access to health care, such as many Latinas, this new hurdle was the last thing they needed. The one piece of legislation that really affects immigrant women because it kind of creates racial profiling of women, said Veronica Baetti Flores, policy research analyst for the National Latina Institute for Reproductive Health. Obviously, legislation like PRENDA really targets immigrant women because it puts a lot of fears at the hand of the provider and the patients, and again targets women of color, particularly immigrants. In addition to Prenda, the state also passed House Bill 2416 in 2011, which restricted who was allowed to provide RU-486 and banned telemed programs, a two-pronged approach that left some clinics in the state no longer able to perform abortions. Planned Parenthood Arizona challenged House Bill 2416 as significantly increasing hardship for women who wanted access to legal first trimester abortions. What we're specifically contesting are aspects of the legislation about nurse practitioners and physician's assistants providing this care, even though they have been providing this care in Arizona for over a decade with exemplary quality and safety ratings. Brian Howard, President and CEO of Planned Parenthood Arizona, told the Arizona Republic, "There is no medical evidence that they should be prohibited from providing the care, and we know that given the shortage of physicians willing to provide this care, it will have significant impact and place a burden on patients." In early 2012, while the U.S. Senate was debating the Blunt Amendment, which would allow religious employers to refuse to add birth control and other medical coverage they found objectionable to their employee insurance plans, Arizona was preparing to go a step farther. The state Senate approved House Bill 2625, which would permit employers to pick and choose whether birth control pills should be covered by insurance plans based on what the employee in question was using them for. If it was for a legitimate medical condition, the medication would be covered. However, if the woman was taking the pills to prevent pregnancy, coverage would be denied. The ACLU of Arizona lashed out at what was not just a violation of women's right to privacy, but an obvious case of gender discrimination as well. Public Policy Director Holly Abraham argued in a statement, "The ACLU is opposed to the bill because it allows employers to impose their religious beliefs on their female employees and deny them access to important health care in the process. It eliminates an existing anti-discrimination law that prevents employers from discriminating against women who independently obtain contraception from another source, and violates women's privacy by forcing them to prove that they're using contraception to treat a non-objectionable medical condition such as endometriosis in order to get coverage. Even in those limited circumstances involving medical conditions, women would still have to pay out of pocket for their medications. Proving a non-objectionable condition would likely require verification from a medical practitioner, since it's doubtful an employer would just take a woman's word at face value. Few women are trusted to tell the truth when it comes to trying to get reproductive health services. She'll lie to get what she wants. The argument isn't a new one, especially in regard to pregnancy. Multiple lawmakers have asked that rape and incest exceptions be eliminated from abortion bans based on the assumption that women would start lying about being raped just to get an abortion. Best known of these politicians was Idaho Senator Chuck Winder, who noted during closing speeches on behalf of the state's mandatory ultrasound bill in 2012, "I would hope that when a woman goes into a physician with her rape issue, that physician would indeed ask her about perhaps her marriage. Was this pregnancy caused by normal relations in a marriage, or was it truly caused by rape?" Winder later clarified that he meant that a woman would want to learn whether she had been impregnated by her husband or the rapist based on the age of the embryo or fetus, not that he necessarily thought women were lying about being raped. By that point, however, his words had been splashed across the national media, and the backlash was believed to be part of what forced the bill to be pulled. That a doctor's judgment could trump the views of that woman when it came to her reproductive desires became an overarching theme in Arizona. According to Dr. Gabrielle Goodrick of the Phoenix-based Camelback Family Planning, it had become the standard practice among some doctors in the state to withhold medical information from their female patients to ensure that they didn't seek out an abortion due to a problem with their pregnancies. I had a patient come in who was told she couldn't have an assessment of the pregnancy by ultrasound until 20 weeks, recalled Goodrick. "I didn't understand. They are told they have to wait another 4 weeks for an evaluation or more detailed ultrasound to look for abnormalities. I think it's already happening. A lot of the doctors here are extreme in their opinions. There are really conservative doctors here, and they already aren't being forthright with their patients. If a doctor withholds relevant information in the course of diagnosis and/or treatment, and a patient relies on that incomplete information to give her informed consent, and she is later injured as a result, the doctor has committed an act of medical malpractice. This was a problem for Arizona lawmakers intent on providing medical providers with every incentive possible to dissuade women from obtaining an abortion. To solve this problem of their own creation, in early 2012, the state advanced House Bill 1359, a wrongful birth bill that would shield doctors from any sort of malpractice suit that developed as the result of any misdiagnosis of a fetal anomaly, especially one that might cause a woman to consider terminating her pregnancy. Sponsored by Republican Senator Nancy Barto, the bill aimed to eliminate that if a child is born with a disability, someone is to blame. House Bill 1359 would protect a doctor if he or she chose not to inform a patient that her developing fetus had a condition that could significantly impact its life. Allowing doctors to withhold information to drive a particular medical outcome means that instead of receiving an objective inquiry into her health and advice based on what medical profession as a whole considers competent care, a pregnant woman will instead receive treatment determined by the individual beliefs of the doctor. This shifts the woman from the primary patient to, at best, a secondary consideration. If Casey tilted the balance to favor potential fetal life over actual maternal life, then wrongful birth bills break the scale altogether, as women can never be sure that the medical information they're receiving is accurate and unbiased, nor can they sue in the event that the information is found to be wrong or negligent. This requires women to exercise great caution and even be stronger advocates for their own care, as what constitutes accepted medical practice will no longer be easily determinable. Wrongful birth laws essentially assign pregnant women the same legal standings as juveniles or persons under legal guardianship and conservatorship, making them devoid of the ability to consent to a full course of medical treatment on their own behalf. Ultimately, the impact of these bills will reach far beyond abortion politics. For example, birth injury suits represent a significant portion of medical malpractice cases, in large part because the costs associated with the act of negligence during pregnancy and delivery are so great. Insurance companies typically and usually successfully fight coverage for these costs. As a result, for many families, malpractice recoveries represent the only financial means of providing for a disabled child. Wrongful births will allow these claims to go uncompensated because all a healthcare professional will be able to do to avoid liability is justify his or her course of treatment in terms of seeking to prevent an abortion. The creation of a medical malpractice shield strips women of the ability to be compensated for substandard medical care rendered to them while pregnant. Wrongful birth laws also completely shatter the bond of trust between doctor and patient. How can a woman go through a pregnancy not knowing if she should believe her doctor when he or she says the baby is healthy? Many women may not even realize the position their doctor takes on abortion until they find themselves in a situation that involves a medically futile pregnancy. Those who do learn their doctor's views are often shocked by the news. Dr. Goodrick told the story of one patient who was warned that if anything was wrong with her baby, she would still be expected to give birth. Before the patient even said anything, the doctor came in and said, "If you have any testing, or even if it's Downs, every baby deserves a chance at life." The patient hadn't even opened her mouth, and the doctor was already telling her the rules, that she would not support her if anything was wrong with the baby because every baby deserves life. The reason it was so important for Arizona to make sure that doctors would be shielded from potential lawsuits if a baby was born with a previously undiagnosed disability that would normally have led a family to consider abortion was because the state was about to introduce House Bill 2036, the Women's Health and Safety Act. House Bill 2036 would take the fetal pain abortion ban Nebraska had passed 2 years earlier and twist it into a bill that could entirely change how women prepared for and dealt with potential complications in wanted but medically flawed pregnancies. Although fetal pain abortion bans had been spreading across the country ever since Nebraska passed theirs in 2010, they had all been based on the same cutoff point, 20 weeks post-fertilization or 22 weeks gestation, a standard medical concept for dating pregnancies based on when the woman's last menstrual cycle. With House Bill 2036, Arizona decided to instead set the cutoff for obtaining an abortion at 20 weeks gestation. By choosing to begin their ban 2 weeks earlier, based on the argument that abortion becomes increasingly more dangerous than childbirth by 20 weeks gestation, with ever-increasing risks beyond 20 weeks. Not only would Arizona be further eroding the rights established in Roe v. Wade, but the state would be taking away women's rights to decide whether or not to carry the term a fetus that was genetically compromised or that faced major health risks. I yield the mic.
My name is Dina Vanderzal, and I'm back again, and I would like to take a moment to really thank these women that have come from Arkansas and Iowa to stand with the Missouri women. I think that's really inspiring and says a lot about how passionately women feel about this, not just within the state of Missouri, but all around the country. The 72-hour bill is something that I've been following since it began. I testified in the House and Senate committees against this bill, and I have spoken with legislators about it, and it's something that has become very meaningful to me, and I'm disheartened to see it continue to pass through, and I hope that Governor Nixon is listening to the women that continue to speak out against these bills. I'm going to read to you the testimony that I gave in the Senate against these bills. My name is Dina Vanderzal, and I'm here today once again to testify in opposition to House Bills 1313 and 1307. I have spent hours and indeed days contemplating my position on these bills. I wrote my testimony, traveled to the State House, waited through the hearing until I had an opportunity to speak, chose to take the recommended waiting period of 72 hours, rewrote my testimony, traveled once again to Jefferson City, and am now ready to share my unwavering opinions. Again, I will highlight that I'm quite fortunate in my ability to do all of this. There are plenty of women, several of whom have reached out to me over the past several days, now months, who would like to be here, but they cannot. They are working, they're paying to pay their bills, and they're caring for their children. They should not be silenced because they do not control their work schedules. I will leave the statistics, research, and legal aspects to the lobbyists, doctors, and lawyers to discuss. I'm here to represent the population whose lives will be directly impacted by these bills. I want to be sure that women are being heard and that women are being taken into consideration when women's health issues are being debated. I hope that my words and actions have illustrated the senselessness of a government-mandated delay of 3 days or more. It is demeaning to all women to tell us that we take our medical decisions lightly, or that we cannot think fast enough to make a sound decision in a 24-hour period. We do not need politicians to protect us from making decisions on a whim. I find it even more insulting to be asked to appreciate such a measure. It begs the question of when our legislators went into the business of being thought police. Women already make careful decisions in consultation with their healthcare providers about whether to raise a child, choose adoption, or have an abortion. Also, and I cannot stress this enough, no healthcare provider forces a woman to make this choice in 24 hours. It is not a special offer, which once expired can never be used. A woman is free to take days or weeks to consider her choices. The point here is that as a woman does not need a mandated minimum thinking period. In the House committee, I heard sponsors of the bill give flawed analogies, saying that because people can and do take a long time to think about other medical procedures, such as a knee replacement surgery or cancer treatments, then women must take this amount of time to think through their private medical choices. The correct analogy would be, because people can and do take extra time to think about these other medical procedures, women can and do have that right before having an abortion. Fortunately, that analogy reflects what is already happening today. Perhaps more important than the offensive assumptions about the mental faculties of female Missourians is that this bill is the beginning of a slippery slope. It terrifies me that this year you may pass a law mandating a 72-hour waiting period, because surely that will not be enough. Clearly, 24 hours did not satisfy our legislators for long. It is a step towards making abortions logistically impossible since they are not illegal. Why 72 hours? That arbitrary number is the source of my fear, because next year you could decide that it should be 5 days. After that, why not make it a week, a month, or 9 months? as Representative Moon mentioned last night in floor debates. What is to stop such a gross assault on women's rights to safe and legal health care once you begin chipping away at them with mandated waiting periods to help women? Let me make my opinion very clear. These bills do nothing to help women stay healthy. In fact, they are a step in the decidedly wrong direction. I realize that one's position on abortion is far more complicated than one's position on a bill, but supporters of this bill seem to have lost sight of the complexity of the situation and women's basic human rights. I would never presume to speak for another individual woman's experience, just as I would never want another person to speak of her mind. But a woman's choice over what to do with her body, her life, should be up to that woman and her healthcare provider. If she chooses, that discussion can be open to her family, her faith, and her friends. But politicians do not have any place in my or any other woman's private decisions. The fact that this is the only medical procedure in which our politicians are seeking to insert themselves speaks volumes to me about their motivation. These bills are clearly rooted in moral values and attempt to create barriers for women trying to exercise their legal rights. If that is not true, then why do we not need a mandated waiting period before making every healthcare decision? After 72 hours, and now much more than that, I did not change my mind, and I will not change my mind. I continue to stand in opposition to these bills. I will now pick up reading where my fellow activists left off, from Crow After Row in Chapter 12. Most genetic issues or anomalies cannot be detected via ultrasound until close to 20 weeks gestation, which is why a gender scan isn't offered until close to that time in pregnancy. By creating a ban that would go into effect near or even before the time that many women would learn about such problems, the Arizona legislature was taking the decision about how to deal with such pregnancies out of the mother's hands. Women would either have to decide immediately whether or not to terminate their pregnancies or else be forced to carry doomed fetuses simply because they waited too long. A state that believed a woman should have to wait 24 hours after meeting with a doctor to terminate a pregnancy that she didn't want now thought that a woman should rush into terminating a wanted pregnancy, possibly before she'd even finished follow-up care and confirmation of any health abnormalities. These were the concerns that Dr. Paul A. Isaacson, an OBGYN who works with high-risk pregnancies, expressed when he testified against the bill in March of 2012. In normal prenatal care, an ultrasound to assess the fetus is done in the 18 to 20 week range. Prior to that range, an accurate fetal survey can't be done due to the small fetal size and immaturity of the organs. If an initial fetal ultrasound assessment shows a suspected abnormality, the patient is typically referred to a perinatology practice for a more thorough ultrasound. It may take several days for that to be arranged. If a severe fetal anomaly is confirmed, the woman may then need time to reach a decision about whether to terminate the pregnancy. For such women, this bill would force them to carry to term, often at substantial health risks to themselves. The legislature rejected Dr. Isaacson's plea and in April 2012 passed House Bill 2036, which Governor Brewer signed. The law was scheduled to go in effect on August 2, 2012. Unlike the Nebraska fetal pain bill, House Bill 2036 was challenged in court. On July 13, 2012, the Center for Reproductive Rights and the American Civil Liberties Union filed suit on behalf of Isaacson and two other Arizona physicians who claimed that the 20-week gestational ban would harm their ability to meet the medical needs of their patients. This law in Arizona displays a callous disregard for the complicated and very difficult circumstances many pregnant women face. And yet proponents of the law have the audacity to claim that it is designed to protect women. Nancy Northrop, president and CEO of the Center for Reproductive Rights, said in a press release. While CRR's lawyer, Janet Krebs, decried the bill as an example of legislators playing doctor. When state legislators attempt to practice medicine, they get it wrong and women pay the price. By imposing criminal penalties, coupled with extremely narrow health exceptions, this law requires physicians to endanger the lives and health of their patients. Judge James Teelberg, an appointee of President Bill Clinton, presided over the case in the U.S. District Court for the District of Arizona. Janet Krebs presented a straightforward challenge to the Arizona law, arguing that states are forbidden from banning abortions prior to viability. Tilburg disagreed and asked Kretz a series of questions about which abortion procedures might be involved and the relative frequency of each. He then lectured her for what he believed was a lack of compassion for the unborn, echoing the increasing concern in the federal judiciary over fetal rights. Tilburg said that he read the plaintiff's affidavits and found that they, quote, reflect profound compassion and concern for their patients, the women, and presumably the fathers, end quote. However, he added, I didn't find anywhere in those affidavits any expression of concern by the plaintiff's position for the unborn child, or even a hint of concern for their part. That was when it became clear that Tilburg was ready to take on Roe. Given that silence on that part, he continued, and given the silence in your own presentation, doesn't that underscore the legitimacy of the state's regulatory action out of concern for the unborn child? On October 30th, 2012, Tilburg issued his order and refused to block House Bill 2036 from going into effect. Barring emergency intervention, Arizona had just successfully enacted the most restrictive abortion bill in the country. Perhaps more importantly, Tilburg's decision set up a question that seemed perfect for the anti-abortion Roberts Court to grab onto. In light of the Gonzalez decision that bans partial birth abortions, both pre- and post-viability, what other pre-viability bans can survive constitutional scrutiny? For Tilburg, House Bill 2036 was constitutional because it wasn't a ban, but a regulation. House Bill 2036 does not prohibit all abortions after 20 weeks gestational age. Rather, House Bill 2036 regulates abortions that take place after 20 weeks gestational age. Accordingly, House Bill 2036 does not purport to ban all abortions past 20 weeks gestational age. Further, the statute allows for abortions up to and including 20 weeks gestational age. As such, House Bill 2036 is not a ban on pre-viability abortions, but rather a limit on some pre-viability abortions between 20 weeks gestational age and viability, which is undisputably occurs usually between 23 and 24 weeks gestational age. Once Tilburg did away with the idea that viability posed any true obstacle to finding House Bill 2036 unconstitutional by calling it a regulation, not a ban, he attacked the plaintiff's arguments that the ban would force women to carry to term fatally flawed pregnancies because most fetal anomalies are detected outside the 20-week window. Plaintiffs argue that a pregnant woman needs time to make the extremely difficult decision as to whether to continue the pregnancy, and in such a situation, it will take longer than 20 weeks to make such a decision. Accepting these statements as true, while House Bill 2036 will make it necessary to make an immediate decision as to whether or not to have an abortion in some cases, such a time limitation cannot be construed to be a substantial obstacle in the right to make the abortion decision itself. One of the footholds Tilburg used to justify his ruling was that House Bill 2036 impacted only a small number of women in the state, those seeking abortions between 20 and 23 weeks. While the number of women potentially injured by a law shouldn't matter, a law should be no less constitutional because it injures the rights of a few. In a 2006 Supreme Court decision found that anti-abortion bills that restrict the rights of a few women are not unconstitutional. In Ayette versus Planned Parenthood of Northern New England, the court refused to strike down a New Hampshire parental notice law on the grounds that it would affect only a small number of people. The law prohibited doctors from performing an abortion on a minor until 48 hours after written notice was provided to a parent or guardian. It also included a judicial bypass provision, allowing a minor to seek a court order permitting the abortion without her parents' knowledge, and an exception where an emergency abortion was needed to prevent the minor's death. Before the law took effect, 3 abortion clinics and an abortion doctor filed suit seeking to overturn it on the grounds that in a small percentage of cases, the minor's health would be threatened without a prompt abortion. The state of New Hampshire asserted the judicial bypass provision would in fact allow for prompt abortion in such cases. The Supreme Court ruled that striking down the law on its face was not necessary or justified, since only a few applications would present a constitutional problem. The opinion in the case was drafted by Justice Sandra Day O'Connor. It would be the last of her career before she retired from the court, and the decision seemed to reflect this fact, as the opinion went out of its way to find a reason to support the law, or as much of it as possible, while still keeping the principle of Roe in place. This was to be O'Connor's final attempt to find a middle ground between the hardening anti-choice fraction in the court, her own ambivalence towards abortion rights, and the reality that Roe was under threat. When confronting a constitutional flaw in a statute, she wrote, we try to limit the solution to the problem. We prefer, for example, to enjoin only the unconstitutional applications of a statute while leaving the other applications in force, to sever its problematic portions while leaving the remainder intact. Legislators were now essentially free to pass laws they knew were in direct conflict with Roe, with the promise that those laws would be allowed to go into effect while constitutional challenges played out. Furthermore, the opinion made clear those future challenges would have to come from an individual woman or provider who had suffered an actual injury and who could challenge the law as applied to them. By clearly favoring as-applied challenges to abortion laws, the court had erected yet another barrier for women needing abortion care. If Gonzalez had provided anti-abortion legislators with a roadmap to follow to make sure their abortion restrictions survived constitutional review, Guyette was an example of the courts in upholding abortion restrictions that were drafted specifically in conflict with established precedent. The Center for Reproductive Rights filed an immediate appeal of Judge Tilburg's decision. The Ninth Circuit Court of Appeals then issued an immediate emergency injunction blocking House Bill 2036 from taking effect while the constitutionality of the law was appealed. Sadly, however, whatever decision the Ninth Circuit ultimately delivers will be largely irrelevant. The reversal of the district court ruling would all but guarantee an appeal to the Supreme Court. And since both legislators and attorneys for the state of Arizona have said publicly that House Bill 2036 is designed to present a direct legal challenge to Roe, a reversal by the Ninth Circuit would be exactly the outcome anti-abortion advocates are hoping for. Letting the decision stand, on the other hand, would leave those women most at risk in Arizona with almost no reproductive health care at all. And as we've seen it with other abortion restrictions, other states will follow suit. Should abortion opponents receive a favorable opinion, allowing fetal pain to become the new standard for creating abortion bans, they will then introduce more medically disproven science, claiming that a fetus can feel pain earlier and earlier, leaving women who live in states that don't affirmatively legislate to protect reproductive health with no access at all. Without a change in course, it will no longer matter what Roe says. Women will have been legislated and educated out of full and legal citizenship. Taking back control. To end the growing segregation when it comes to women's health and care and reproductive rights, several steps need to be taken. First, we need to roll back the anti-abortion, anti-contraception initiatives that have sprung up like weeds in several states with conservative majority in their legislators and a conservative governor at the helm. Along with that, we must also block new anti-women's health laws from being passed. But more importantly, in order to establish a truly equitable healthcare system that isn't limited based on gender, race, location, or economic means, we need to propose laws that make abortion, family planning, pregnancy prevention, and health screenings a personal right, and that also expand the number of people who can provide those services. To do all of this, we must elect individuals to Congress who will push pro-women initiatives, as well as recruit and support such candidates as the state and local levels. It took a wave of elections in the 2010 midterms to create the current atmosphere that has allowed anti-choice policies and laws to be passed in state legislators all over the country. Many of the bills discussed in this book were introduced in the wake of that wave in states that already had demonstrated hostility toward women's reproductive health and rights. At the state level, I really do believe that people thought that these Tea Party conservatives wanted to work on jobs and the economy, Elizabeth Nash of the Guttemacher Institute said of the 2010 election. Instead, these folks walked into a system that had already been stacked against abortion rights because there had been a number of anti-choice successes over the past years. So there was already essentially a network in place for passing abortion restrictions, and these new conservative candidates came right into it. States such as Wisconsin were able to take advantage of the rare trifecta of every branch of government being under Republican control, which made it possible for them to pass numerous abortion restrictions that normally would not have made it into law. However, we will not be successful in electing politicians who support women's rights unless we first establish an activist base from which potential candidates for office can draw resources and support. According to Gloria Felt, a former president of Planned Parenthood, what is needed is a strong, energetic core, not unlike a feminist version of the personhood movement that has been popping up in a variety of states. Just as these personhood efforts are not coming from the mainstream anti-choice groups, she says, I'd love to see a band of feisty young feminists out there leading the charge on this, saying, excuse me, we are persons, and we want our personhood guaranteed. Felt herself took a feisty stance when she became the national president of Planned Parenthood, particularly on the issue of contraceptive coverage. Why did we choose that one? She asked rhetorically. Because we know that almost every single American citizen uses birth control at some point in their lives, and that cast the bigger net when it comes to bringing people to your side. The abortion issue and birth control issue at their core are the same issue. Those people who oppose abortion are pretty much the same people that oppose contraception coverage or funding for family planning or anything related to it. So it gave us a way to move the agenda. Now almost every insurance plan covers contraception. It's not perfect. They'll do high deductibles, they'll do all kinds of things to try not to pay for it, but now contraceptive coverage is standard care. Felt's work helped pave the way for copay-free contraception in insurance plans under the Affordable Care Act, showing that what begins as activism can eventually make its way into governmental policy. In addition to echoing Felt's words on the close relationship between contraception and abortion, the Affordable Care Act has also created an opportunity for policy changes involving abortion coverage and insurance plans. Several states in the past few years have proposed bills that extend insurance coverage of abortion, making abortion an essential part of health care, expand access determinations, or to seek to make contraception more readily available. In Connecticut, the legislature declared abortion to be an essential benefit that had to be included when the state selected its insurance exchange program. This issue is favorably resolved for all women now in Connecticut. Jennifer Jaffe, an advisory committee member for the Insurance Exchange Health Plan, told Connecticut Mirror in June of 2012, stripping women of elective abortions is not a tenable option. There is also the problem of women who are covered under private insurance through their employers who have no reason or incentive to offer abortion and contraception coverage. That is why more states need to push beyond the welcome but still limited options provided by the Affordable Care Act and turn to the example set in Vermont, which took the coverage of the ACA offered via state exchanges a step further, providing what many progressives in the country had hoped to see implemented, universal health care. Governor Peter Schulman signed House Bill 202 into law in May of 2011, saying, "We gather here today to launch the first single-payer healthcare system in America, to do in Vermont what has taken too long, to have a healthcare system that is the best in the world, that treats healthcare as a right, not a privilege, where healthcare follows the individual, not the employer."
Hi, my name is Mandy Laddie. I am from Columbia, Missouri, and I'm here today to speak for the women who can't. And I'm here to speak against this dangerous legislation. I think it's both paternalistic and insulting. And I'm here because I believe that the legislatures behind this bill, who feel that it's their obligation to take away our choice, need someone to speak out against them. So I'm going to pick up where Dina left off. Until more states agree with Vermont that health care is a right, there needs to be a concerted effort to guarantee that abortion is not limited by the policies of the federal government. Unfortunately, since the 1976 passage of the Hyde Amendment, the government has increasingly restricted poor women's rights to access abortion. Like many other abortion restrictions, the Hyde Amendment started out acknowledging a wide range of allowable circumstances that were slowly chipped away over the years. For example, the original amendment allowed Medicaid to pay for abortions in cases of rape, incest, life endangerment, and physical health damage to the woman. For 2 years after it went into effect, the exception for physical health was dropped. 2 years after that, the rape and incest exceptions were dropped as well and were not reintroduced until 1993. There are so many low-income women and Latinas who depend on Medicaid for their primary source of health care, and for abortion services not be covered by Medicaid is a huge barrier for them, explains Veronica Valletti Flores of the National Latina Institute for Reproductive Health. It seems completely hypocritical that there are a few women in power who can decide for low-income young women or women of color what is best for them, and they're not given the dignity to decide for themselves. If the federal government cannot ensure that women, regardless of their economic means, have access to abortion, then the Hyde Amendment should be repealed. This is an issue we have been involved in since we were founded in 1993, says Stephanie Pogge, Executive Director of the National Network of Abortion Funds. NNAF and several other reproductive justice organizations, including the National Latina Institute for Reproductive Health, have formed a broad-based coalition dedicated to removing the ban on abortion coverage for women enrolled in Medicaid, regardless of what state they reside in. We see how painful it is. How many women aren't able to raise money to get an abortion, Pogge says. We talk to so many women every day who are in need of our help in order to exercise their legal right, their constitutional right, their human rights as a woman and a person to be able to decide what's best for them and their lives. Women are going to great lengths, and they're not able to come up with the money, and that is because of the Hyde Amendment. According to the Guttmaker Institute, between 18 and 35% of women who want an abortion and are on Medicaid continue their pregnancy because they cannot afford to terminate. One of the arguments of those who oppose abortion is that no woman has ever said later on that she regrets having her child. Couldn't it be argued that cutting off a woman's financial ability to obtain an abortion is, in the long run, a positive thing? Not at all, according to Pogge. It's never a good thing to take away someone's rights. Women who are compelled to have a child when that's not the right decision to make will do the best they can. They may face poverty, they may really struggle to even meet basic needs, but they absolutely do the best they can. But the fact that women and families do the best they can in really difficult circumstances is no argument for heaping difficult circumstances upon them. The coalition plans to engage in movement building to provide supporters with the information and tools they need to explain how the Hyde Amendment harms women. Their goal is to educate not just reproductive justice supporters, but other progressive organizations and policymakers as well. We know that this is not something we can win overnight, that is clear, Pogge says of the effort, which is already underway. But we're ready to come together and say, that's it, we're through with letting the Hyde Amendment do its damage. While expanding a woman's ability to pay for an abortion, or at least have some or all of it covered under some form of insurance or medical assistance, by eliminating the Hyde Amendment would be an important step for reproductive rights. Unless the number of abortion providers is increased, women will still find themselves without access to the procedure in a timely manner. Since the longer a pregnancy progresses, the more complicated and costly a termination becomes, having enough medical professionals who are able to abort abortions is vital. This is an issue that those who want to end abortion have been focusing their efforts on in recent years. As Dr. Michael New, a fellow at the conservative think tank the Witherspoon Institute, wrote in Life News, in the years since Roe v. Wade, pro-lifers have mostly focused on what would be called demand-side legislation. In short, legislation that was designed to make it more difficult for women to obtain abortions by either imposing legal barriers or increasing the economic cost of abortion. However, in recent years, pro-lifers have pursued what would be termed supply-side strategies. These are strategies that are designed to make it more difficult for abortion providers to either stay open or perform abortions. Overall, this has been a wise strategy for pro-lifers. Better yet, good research shows that fewer clinics result in fewer abortions. Even before TRAP laws began limiting the number of doctors who could provide abortions, the community of providers was already dwindling, decreasing by 38% between 1982 and 2005. Doctors who had begun practicing in the years following the Roe ruling, and in some cases before that, were starting to retire, and many of the new doctors coming into the profession were showing less interest in providing abortion. It's little wonder what fewer are interested, as being a provider since the 1980s has meant constant harassment at clinics, as well as a growing sense of danger from a volatile anti-abortion movement that ever since the assassination of Dr. George Teller has carefully balanced an undercurrent of violence with a plausible deniability that allows it to claim that every incident is the work of a lone wolf unaffiliated with the movement. Add in burdensome licensing and insurance regulations, new laws that allow providers to be sued by patients, their partners, or boyfriends, even extended family, and requirements that providers act as counselors to determine if a woman was coerced, or might have mental issues, and it is not surprising that many doctors today are not interested in offering abortions. On top of that, fewer doctors are being trained on how to perform abortions than ever before. According to the National Abortion Federation, a survey in 1998 revealed that the first trimester abortion techniques are a routine part of training in only 46% of America's OBGYN residency programs. About 34% offer this training only as an elective, and 7% provide no opportunity at all for young doctors to learn to provide safe abortions. Medical Students for Choice compares, stating that 97% of family practice residents and 36% of OBGYN residents have no experience in first trimester abortion procedures. While Medical Students for Choice notes that medical schools are simply not addressing the topic, it is difficult for many to do otherwise when states are coming up with new and creative ways to cut back on training, such as the Kansas bill that attempted to end training for abortions at the publicly funded University of Kansas Medical Center. A federal version proposed by North Carolina Congresswoman Virginia Foxx was intended to cut off federal funding to any medical training program that might teach abortion procedures, a move that caused one House colleague to object, noting, "It's really not wise to have ignorant physicians." Fortunately, Foxx's bill failed. In early 2012, California State Senator Christine Kehoe introduced Senate Bill 1501, which would have allowed nurses, nurse midwives, and physician's assistants to provide first trimester surgical abortions, a change that would have greatly expanded access for the large rural population of the state. Unfortunately, the Senate committee in charge of the bill balked at the proposal. Although first trimester surgical abortions are one of the safest medical procedures, the bill was also panned by the California Nurses Association. Kehoe then tried to revamp the bill, limiting the new eligibility to nurses who had already completed a pilot program in first trimester aspiration abortions. However, even that was too controversial for the committee. Kehoe vowed to bring the bill back one day, saying in a statement, "The issue of access to early abortion care for women across California remains an important issue, and we will continue to review our options for ensuring that all women have access to care by providers they know and trust in the communities where they live." Assemblywoman Toni Atkins submitted a new bill in the 2013 legislative session, which at the time of publication has yet to be heard. Kehoe's proposal may not have succeeded, and the jury is still out on the Atkins bill, but there is no reason why similar legislation cannot be proposed in other states. It is only recently that abortion, both surgical and medication, has been limited so drastically. The lack of a consistent standard across the country should make it clear that what is required of an abortion provider has more to do with the whims of a state's legislator than with medically proven practice. Mississippi's requirement that a provider be a board-certified OBGYN and have hospital admitting privileges, for example, is meant to reduce the number of doctors who can perform an abortion, not to protect patient safety. If a state were to propose a bill mandating who was allowed to deliver a baby, and the process prohibiting general practitioners and midwives from delivering babies, and threatening felony charges for anyone assisting in a birth who wasn't a board-certified obstetrician, such a law would never pass. That the same law can be viewed as reasonable when it comes to providing a first trimester abortion is nothing but a political double standard. If anti-choice groups such as Americans United for Life and the National Right to Life Committee can draft anti-choice, anti-reproductive rights model legislation bills that are then farmed out to friendly politicians and states throughout the country, then pro-choice bills can also, and should also, be written and offered to favorable lawmakers to be proposed as a
This is to yield the floor for a question. Good morning. We're home stretch here. Although a woman should have the right to terminate an unwanted pregnancy regardless of her race, income, and where she lives, it is still in everyone's best interest to prevent unwanted pregnancies in the first place. To that end, ensuring that contraception is easily accessible and affordable should be a priority. Yet, as we have seen, a movement has been afoot to eliminate Title X funding, especially for Planned Parenthood affiliates, and to increase protections for those who block access to birth control because of conscience issues. Over 40 lawsuits have been filed against the federal birth control mandate in the Affordable Care Act, mostly by religious groups who are challenging the mandate on the grounds that it erodes their religious liberties. These lawsuits serve a dual purpose. In the short term, they challenge the policy of making contraception widely available and affordable, while in the long run, they reframe the conversation as one in which the very idea of contraception is seen as a controversial issue dividing the American public. In California, Democratic Assemblywoman Holly Mitchell introduced a bill in 2012 to expand access to contraception, proposing that registered nurses be legally allowed to administer birth control. The bill was meant to address long waits at clinics when a doctor or nurse practitioner wasn't available to fill a birth control prescription. The California Women's Law Center wrote in support of the bill, saying, "An essential component of comprehensive reproductive health care for women, hormonal contraceptives are among the safest and widely used medications available today." The bill passed and was signed into law by Governor Jerry Brown, who said, "At a time when some seek to turn back the clock and restrict women's health care choices, California is expanding access to birth control and reaffirming every woman's basic constitutional rights." As reproductive rights advocates like Holly Mitchell push for greater access to contraception, religious conservatives have countered with broad conscience clause claims designed to shield individuals and institutions from having to provide insurance coverage or employment protections or dispensing medications that conflict with their moral or religious beliefs. The effect has been a renewal of First Amendment litigation around the boundaries of religious liberty as it relates to choice. However, the religious or moral beliefs of the person behind the drugstore counter filling a prescription or a company providing health insurance for its employees should not matter under conscience, for the simple reason that refusing to provide or cover contraception is akin to impregnating a woman against her will. So far, the courts have largely agreed, but with a flood of litigation on this issue currently clogging the federal courts, it is all but certain the Supreme Court will have the final say. Well, it is certain. Furthermore, access to contraception, just like any other healthcare issue, should be a right that is not contingent on a person's financial status. But just as anti-choice politicians are limiting who can have an abortion, they are also limiting who can receive birth control. Being anti-birth control isn't a popular stance, which is why anti-choice activists, and especially Republican politicians, have reframed it as an effort against Planned Parenthood rather than revealing their true intention, which is to stop government funding for contraception. That family planning actually saves the government more than it costs by reducing the need for other medical expenses the government must cover, as well as additional social services that must be paid for with tax dollars, is irrelevant to the anti-choice movement. A secondary strategy used by anti-choice activists who wish to eliminate Title X funding is to shift such funding to religious institutions and nonprofits that supposedly provide similar types of services. Governor Rick Perry's scheme in Texas of moving a chunk of family planning money to crisis pregnancy centers was the epitome of the crusade to, on the one hand, refuse to allow taxpayer money to pay for something that one group declares morally objectionable, yet, on the other hand, use government funds to funnel money to religious groups. It is a tactic that was also used in Minnesota, when then Republican Governor Tim Pawlenty signed the Positive Alternatives Act into law in 2005, in essence, greenlighting taxpayer dollars for religious-based crisis pregnancy centers. For pro-choice activists, a reactive counter-approach would be to try to restore lost family planning funding to its original designees, as well as to forbid reallocation, such as in Ohio's attempt to place religious medical facilities ahead of Planned Parenthood clinics in the line to receive funds. A proactive approach, however, would be to ban crisis pregnancy centers and religious hospitals and clinics from receiving any form of taxpayer support, and then have that funding set aside specifically to subsidize contraception. After all, if abortion and birth control funding can be restricted because of the disapproval of certain groups, shouldn't tax dollars going to religious institutes be looked at under the same lens, especially since those organizations are operating without any tax liability in the first place? Such laws would no doubt be controversial and impossible even to propose without the right politicians in legislatures and state houses across the country. Unfortunately, for too long, abortion supporters have relied on the political party apparatuses to keep a woman's right to control her own body safe. But while the GOP has steadily whittled out most of its members who identified as pro-choice, the Democratic Party has been more than happy to embrace politicians who believe that women and men should not have equal rights when it comes to controlling their bodies. In many instances, Democratic groups have led substantial support and resources to those candidates. Of these groups, the Democratic Congressional Campaign Committee has been one of the most flagrant supporters of such candidates, offering its vast email network and soliciting donations on behalf of groups such as the so-called Blue Dog Coalition, a band of ultra-conservative Democrats who, among other issues, don't believe in a woman's right to choose. The DCCC has often viewed reproductive rights as something not worth breaking alliances over. Most egregiously, DCCC Chair Chris Van Hollen called up Michigan Democratic Bart Stupak in 2010, urging Stupak to run for re-election. This plea came shortly after Stupak introduced the infamous Stupak-Pitts Amendment, which removed abortion care from the Affordable Care Act, setting the stage for elimination of coverage throughout state exchanges. The Democratic National Committee hasn't been any more helpful, repeatedly putting money and support behind politicians like Nebraska Senator Bill Nelson, a staunchly anti-abortion Democrat who almost single-handedly derailed health care reform before eventually agreeing to vote with his party and the president. With groups like the DCCC and the DNC basically unsupportive of a woman's right to control her body, it is not surprising that reproductive rights advocates are increasingly looking to non-governmental organizations like Planned Parenthood, Emily's List, and NARAL, Pro-Choice America, as well as state groups like Ruth's List in Florida, Women Winning in Minnesota, the Montana Women Pipeline Project, and New Jersey's Women Advocating for Good Government. Emily's List has worked for over 27 years to elect pro-choice Democratic women to stand up to the conservative right and work toward building a progressive America, says the group's president, Stephanie Sherrod. These Democratic women are the most reliable progressive voting bloc in Congress. They are the most reliable progressive voting bloc for women's health in state legislatures, and these voters are really recognizing that if you want progressive policies across the board, but especially in women's choice, you have got to get more and more pro-choice candidates, and in particular, women. The biggest challenge for these organizations is finding candidates in the first place, particularly female ones. According to She Should Run, an advocacy group dedicated to bringing equity to political representation, women are 50% less likely than men to seriously consider running for office, less likely than men to actually run for office, and far less likely to run for higher office. This is an issue that many organizations and politicians are trying to address. For example, in 2011, New York Senator Kirsten Gillibrand launched Off the Sidelines, a website and social media network that focuses on getting women involved politically. The project's website reads, "From local school board to the U.S. Senate, good candidates are needed to run every year at all levels of government. Right now, women make up only 17% of Congress, and there are only 6 women governors. If you are considering running for any office, attend a campaign school, such as the Women's Campaign School at Yale, which is 1 week in the summer, or training weekends run by the Women's Campaign Forum, Eleanor Roosevelt Legacy, Emerge, Campaign Boot Camp, Emily's List, and other organizations to get a sense of what it is all about." Certainly, sister.
My name is Dina Vanderzalm, and I'm here for many reasons, not one of the least of which is that I am the obnoxiously proud aunt to the most beautiful and intelligent and wonderful 5.5-month-old baby girl. And as frustrating as it is to me that we are still fighting these fights, that I spent the 40th anniversary of Roe v. Wade in a House Committee meeting testifying against the 72-hour waiting period bill, I want so much more for her, and I would rather that we fight this fight now and make it better for our future generations. I'm going to switch it up a little bit and read from a book called The Religious Case for Abortion, Protestant, Catholic, and Jewish Perspectives, which was edited by Hamilton Gregory. I think this is going to be really interesting because so much of what we hear in opposition is a religious argument. And I'll start with the introduction. There are millions of Americans, including many Christian and Jewish leaders, who believe that in some situations, abortion is the will of God. Anti-abortionists disagree, and that's fine. Let them shout their religion from the rooftops. Let them try to persuade all Americans to adopt their beliefs. Unfortunately, however, some anti-abortionists aren't willing to stop there. They want to force their beliefs on everyone else. They want laws passed that will make all abortions illegal. Though public opinion surveys indicate that these anti-abortion extremists are a minority, they form a powerful single-issue pressure group, and many frightened politicians capitulate to them. They have already succeeded in cutting off Medicaid abortion payments to impoverished women, including rape victims. If the extremists do get their way, if they do succeed in banning all legal abortions, they will be denying freedom of religion to the millions of Christians and Jews who believe that God sanctions abortions. It all boils down to religious freedom. But abortion is murder, shout the extremists. According to whom? As the essays and quotations in this book show, the Bible does not consider abortion to be murder. And for 4,000 years, Jewish law, upon which Christianity is based, has never viewed abortion as murder. The fetus is not a living soul until it leaves the womb. Therefore, Jewish law sanctions, and it sometimes even requires abortion when the life and well-being of the mother are at stake. Though official Catholic doctrine now regards the early fetus as a person, it did not always do so. For 18 centuries, abortions were allowed in early pregnancy. It was not until 1869 that the Church prohibited abortion at any time and for any reason. If this book serves no other purpose, it should once and for all squelch the anti-abortionists' smug claims to moral and spiritual superiority. Let the word go forth. Those of us who favor freedom of choice have the indisputable support of the Bible, 4,000 years of Jewish law, and 18 centuries of Catholic tradition. Part 1, Religious Views. Chapter 1, Is Abortion Murder? By Graham Spurgeon. Bible scholar Graham Spurgeon, a Baptist, has written what many consider to be the most persuasive pro-abortion essay ever published in America. Question: What is your position on abortion? Answer: I believe a woman should be free to choose whether or not to have an abortion. No one else should tell her what to do and what not to do. Question: Who wants to deny her this choice? Answer: There are many fanatics in our land who want to make all abortions illegal. Question: Are all anti-abortionists fanatics? Answer: No, and I respect those anti-abortionists who are willing to make concessions in a generous, humane spirit. For example, my esteemed brother in Christ, Billy Graham, approves of abortion, quote, in cases of rape, incest, or when the mother's life is at stake, end quote. When I talk about fanatics, I'm not talking about folks like Billy Graham. I'm talking about those cruel individuals who are against any and all abortions, period. Question: is abortion murder? Answer: the fanatics say so, but they haven't looked closely at the Bible. Let's see what the Word of God says on this matter. In the Old Testament, a law was stated clearly for the children of Israel after they came out of Egypt. If, when men come to blows, they hurt a woman who is pregnant and she suffers a miscarriage, though she does not die of it, the man responsible must pay the compensation demanded of him by the woman's master. He shall hand it over after arbitration. But should she die, you shall give life for life, eye for eye, tooth for tooth, hand for hand, foot for foot. Exodus 21:22-24, Jerusalem Bible. In other words, if you cause the death of the fetus, you merely pay a fine. If you cause the death of the woman, you lose your own life. Thus, the Bible clearly shows that the fetus is not considered a person. If the fetus were considered to be a person, then the penalty for killing it would be the same as the penalty for killing the woman: death. Abortion, then, is not murder. These verses in Exodus, by the way, are backed up by 4,000 years of Jewish law. Abortion has never been considered murder in Jewish law. The fetus is only a potential person. Incidentally, the fine an Israelite man has to pay was not for the fetus. It was for hurting the woman. This is made clear in another translation of the same verse, in a Revised Standard Version. Quote, the one who hurt her, the woman, shall be fined. End quote. There was no fine for hurting the fetus because it was not considered a person. Question, but doesn't life begin at conception? Answer, no, life begins before conception. The sperm is alive, the ovum is alive, long before they get together at the moment of fertilization. As Dr. John A. Henderson says, life does not begin at conception. It is only changed and now has the potential for a different form. If terminating life is murder, then the anti-abortion fanatics should be consistent and say that terminating the life of the egg or the sperm is murder. Believe it or not, there is a crackpot group in California that is making this very accusation. They say that males who masturbate should be punished because they are guilty of wasting human life in the form of semen. Question, if the embryo is a potential person, shouldn't it be treated the same way as a full-fledged person? Answer, an acorn is not an oak, a seed is not a rose, an embryo is not a human being. Nowhere in the Bible is the embryo or fetus given a status of a human being. Personhood does not begin at conception. Question, when does personhood begin? Answer, the Bible indicates that personhood begins when a baby emerges from the mother's womb. In the Bible and in modern life, birthdays are observed on the date of the baby's emergence from the womb. The precise moment of the beginning of personhood is when the baby takes its first breath. Question, why the first breath? Answer, because that's when God infuses the baby with a soul. Genesis 2:7 says, and the good Lord formed a man out of the dust of the ground and breathed into his nostrils the breath of life. And man became a living soul. In other words, when an infant breathes its first breath, the soul enters its body and achieves the status of a person. Question, why doesn't God want every fetus to grow into a person? Doesn't God want every fetus to grow into a person? Answer, not according to the Bible. God compares the rich man who has led an empty, foolish life with a stillborn infant and says, I maintain that the stillborn child is in better case than he. And Jesus said of Judas, it would have been better for that man if he had not been born. The world is better off without Judases and Hitlers and Charles Mansons, who quite often begin life unwanted and grow up abused and hated, and then take out their anger on society. How many psychopaths and destructive misfits will be born if anti-abortion fanatics force women to bear unwanted children? Question, the anti-abortionists say that when conception occurs, that means God wants a child to result. Answer, whoever says that doesn't know biology. Consider these facts. 1. Between 1/2 and 2/3 of fertilized eggs in a woman fail to implant themselves in the uterus. They are washed away unnoticed. 2. In the United States each year, there are about 1 million spontaneous abortions, also called miscarriages. The abortions occur naturally. That is, the fetus is expelled from the womb without the assistance of doctors. In many cases, the woman is relieved of a horribly defective or diseased fetus. Scientists say this is nature's way of handling deformed fetuses. A religious person would say that God is merciful in bringing about the spontaneous abortion. Question: but spontaneous abortion, or miscarriage, is far different from induced abortion, isn't it? Answer: I don't think so. In many cases, abortion by a surgeon is simply a way of assisting nature, similar to the way we take various medicines to assist the natural processes of healing. Let's say that the doctors discover that a pregnant woman is carrying a fetus that is horribly deformed. If abortion doesn't occur spontaneously in miscarriage, then doctors are only assisting what normally should take place. Question: but isn't this going against the will of God and the natural course of things? Answer: is a surgeon doing wrong when he or she cuts out a malignant tumor? Question: why didn't God speak out explicitly on the question of abortion in the Bible? Answer: it wasn't an issue in biblical times, nor was polio, but who would say that the polio vaccine is against the will of God? In biblical times, abortion was not an issue because safe procedures were not known. Nowadays, abortion is safer than childbirth. Statistically, a woman is less likely to die from abortion than from childbirth. Question: why did God wait so long to give the world safe abortion? Answer: the world didn't need it as much in the past as it does now. I think he is showing mercy on us by giving us this safe surgical technique at a time when the world is almost choking to death from overpopulation. Human beings can't take care of the children already on Earth. United Nations health authorities tell us that 1/3 of the world's children die of malnutrition before the age of 5. 1 out of 3. What kind of life is that? I think God is showing us he wants quality, not quantity. Question: the anti-abortionists would say that you are a baby killer. Answer: I happen to love children. I marvel at my own. They are little miracles. They are treasures. It is because I treasure babies that I am for abortion. I want to see that babies are wanted, loved, adored, not babies that are hated and abused and forced into the world because of the misguided zeal of fanatics. Question: some anti-abortionists say that abortions in America constitute a Hitler-style Holocaust. Answer: this is ironic because Hitler, and Stalin as well, outlawed abortion. Totalitarian regimes want to control every aspect of a person's life, including a woman's reproductive system. In America, by contrast, when our founding fathers wrote the Constitution, early abortions were legal. Allowing women to control their bodies is the American way. Treating women like cattle is the totalitarian way of dictators and ayatollahs. Question: won't the American family be weakened by legalized abortion? Answer: no. What would weaken the family is for government to strip parents of their right to decide their family size for themselves. Question: wouldn't widespread abortion make people callous to human life? Answer: no, to the contrary, it would be society's way of saying life is important, children are important, and they shouldn't be brought into the world unless they can be loved and provided for. Child abuse is a sin and a crime. See Jesus' remarks below in Matthew 18:6. Question: but the anti-abortionists say that unwanted children can be put up for adoption. Answer: this is a cruel hoax. All this talk about adoption. There are currently 120,000 children in this country and uncounted millions elsewhere in the world who are unadoptable. Nobody wants them. Blue-eyed, blonde, white-skinned children are quickly adopted, but if a child is black or physically handicapped or mentally retarded, he or she is not likely to find a permanent home. It is a shame, but it is true. Incidentally, there are many black couples who would love to adopt black babies but cannot afford to. Question: can you give an example of a case in which abortion is the desired alternative? Answer: a mentally retarded 12-year-old girl was raped by her father and she became pregnant. Doctor's tests indicated that the fetus was physically deformed with a strong probability of mental retardation. The girl's mother, who was living in terrible poverty, wanted the girl to have an abortion, and her pastor concurred. I think God favored this abortion. There are many other cases, of course, which could also be cited. Question: do you think that babies do come into the world with handicaps? Babies that do come into the world with handicaps should be killed? Answer: of course not. Once a baby is born, it is to be loved and cherished and helped as much as possible. Here's an interesting comment made by a woman who wrote to columnist Ann Landers. I am the mother of a child with Down syndrome. I believe that a special child can enrich one's life. My husband and I have devoted a major part of our waking hours these past 12 years to making sure our son has a full and productive life. Our older children have also made this commitment to their brother. Given the chance, would we choose to have the beloved child again? We would choose to have the beloved child again, just as he is. We would also choose not to bring another one like him into the world. Why? It is not that we lack compassion. It is simply a matter of energy. She goes on to say that she and her husband are strongly in favor of a woman's freedom to choose whether or not to have an abortion. Question. The anti-abortionists talk about the pain the fetus feels during abortion. Is there really pain involved? Answer. Yes, any abrupt change in tissue structure results in distress. Yes, the fetus twitches. But you could carry this pseudoscientific logic to an extreme. Scientists have proven that plants are as sensitive as animals. When plucked by their roots, they scream with an electrophysiological pain. Should we therefore stop harvesting vegetables because of this pain? I am not moved by the pain of an embryo, which is a smidgen of tissue. At 4 weeks, an embryo is no bigger than a kernel of corn. Don't let blown-up photographs mislead you. I am moved, however, by the abuse of a child who's battered and slashed by parents who would never wanted him. Question. Are you saying that the anti-abortionists are indifferent to the pain of child abuse? Answer. That many anti-abortionists are fine, sensitive human beings. The fanatics among them seem to have concern that begins with conception and ends with birth. Columnist Carl T. Rowan says fanatics want to force poor women to have babies, curse them when their children go on welfare, deny the children even a minimum level of decency, then wait for them to get pregnant at age 12 or 13 when they can tell them, no abortions, you must have babies. Question. Don't you admire the anti-abortionists for being motivated by reverence for life? Answer. That's not their main motivation. Their main motivation is revenge. They want to see pregnant teenagers suffer the consequences of their sin. I have seen the evil gleam of vengeance in the anti-abortionists' eyes as they say, she had her fun, now she has to pay the price.
My name is Mandy Laddie, and I'm going to pick up where Dana left off. When the mob wanted to stone the woman who had committed adultery, Jesus said, "He that is without sin among you, let him first cast a stone at her." John 8:7. I'm afraid that if Jesus were to repeat those words today, these self-righteous hypocrites would pick up stones and smash the poor girls who have been guilty of making a mistake. Stoning is not far from what these fanatics are in fact trying to do today. They are not so much pro-life as they are pro-vengeance. Their stones are these cruel words. You must have that baby. To the woman who says, I have 7 children already, the fanatics reply, you must have that baby. To the woman who says, I was raped, the fanatics reply, you must have that baby. To the woman who says, my doctor says I will die if I have this baby, the fanatics reply, you must have that baby. You must have that baby. Words of stone, crueler than the stones hurled at sinners in Jesus' day by self-righteous Pharisees. Question. Isn't it a good thing for teenage girls to be made afraid of getting pregnant? Doesn't this discourage premarital sex? Answer. I share the anti-abortionist concerns about teenage sex. I think it's wrong. We should try to discourage teenage sex and teach young people that sex is a part of marriage. But studies show that fear of pregnancy does not deter sexually active teenagers from having sex. They have the attitude, it won't happen to me. Question. Well, shouldn't pregnant teenagers be made to suffer the consequences of their wrongdoing? Answer. If the girl wants to go ahead and have the baby, fine. But she shouldn't be forced to have it. Why? Because the one who will suffer the most is not the mother, but the child. Unwanted, unloved children are frequently abused, and they often grow up to become delinquents and criminals. Then society is made to suffer as well. The punishment of the mother is enormously out of proportion to the crime. Question. How do you know that unwanted children often become criminals? Answer. There are dozens of studies, but let me cite just one, by the late Mickey McConnell, a prison minister. Approximately 80% of the people in prison were unwanted and unloved children, and a large majority of the mass murderers and violent killers in American history were brutalized children. Imagine our society if every child is wanted, is taken care of. We would virtually wipe out crime and close most of our jails. As someone once said, there wouldn't be anyone on the FBI's most wanted list if these men had been wanted by their parents when they were little. We would avoid stunted, thwarted lives. We would eliminate poverty and the grinding burden of welfare. We would see the flowering of every person's intelligence and humanity. Question. Anti-abortionists tell women who have had abortions, aren't you ashamed? And don't you wonder night and day what the baby would have looked like? Answer. This is just part of the vicious, insensitive campaign to make women feel guilty and sinful for having had an abortion. As I have already pointed out, most fertilized eggs fail to implant themselves in the uterus and are washed away unnoticed. Should a woman weep and wail over all of these lost children? Shouldn't a woman who has had an abortion feel some amount of shame? No. There is no need for her to hang her head in shame. She is showing respect for life and devotion to God when she says, life is too precious for me to bring a child into the world at this time. I want to wait until I have the money or the emotional resources to be a good mother. Question. Aren't all good Christians opposed to abortion? Answer, no. There are many, many denominations that either favor abortion or favor a woman's right to decide for herself. The people in these denominations outnumber the fanatics. Here are just a few of the national religious organizations which have come out in favor of a woman's right to have an abortion. American Baptist Churches, American Jewish Congress, the Disciples of Church of Christ, Church of the Brethren, Episcopal Church, the Lutheran Church in America, Presbyterian Church in the United States, Reorganized Church of Jesus Christ of Latter-day Saints, the United Church of Christ, the United Methodist Church, and the United Presbyterian Church in the USA. Question. Since the anti-abortionists are so sincere in their views, shouldn't their views be written into law? Answer, no. Because putting their views into law would take away my freedom of religion. It would mean that they would force their religious beliefs upon me. The Jehovah's Witnesses don't believe in blood transfusions. That's fine. What if they tried to get the laws changed so that a blood transfusion was illegal? I believe that abortion is sometimes a Christian and humane alternative. I believe that God wants us to bring into this world only the number of children which we can adequately take care of. I believe that God has given us this safe surgical procedure as a gift to hold down the population in a world that is choked with too many people and not enough food. A world that is filled with wretched, unwanted children. I'm thankful to God for abortion. Anyone who reads the Bible with an open mind, and more important, an open heart, will see that our Heavenly Father wants quality, not quantity, for His children. Now I'm going to read some Catholic perspectives. Almost all public opinion show that the overwhelming majority of lay Catholics favor a woman's right to choose an abortion if she so desires. Moreover, studies of abortion clients reveal that Catholic women have abortions themselves as frequently as Protestant or Jewish women. The big difference between Catholics and other denominations is the attitude of the clergy. The majority of Catholic priests and theologians oppose abortion, and many of these clerics have been in the forefront of the battle to ban all abortions. But pro-choice priests have begun to speak out against the official Catholic doctrine. Father Joseph F. Gonso, a Jesuit theologian, says, "There is a minority Catholic opinion, which has good standing in the Church, which was the opinion of her greatest theologian, Thomas Aquinas, and which is now slowly regaining favor among Catholic thinkers. This minority opinion holds that the embryo is certainly not a human being during the early stages of pregnancy, and that, consequently, it is not immoral to terminate pregnancy during this time, provided there are serious reasons for such an intervention." Here are some other pro-choice Catholic positions. Father Joseph O'Rourke, Catholic coordinator of the Interfaith Center for Corporate Responsibility of the National Church of Churches. If the Church was to stand sincerely against abortion, it would reorient its social and relief services to stop the 100 spontaneous abortions or miscarriages for every 200 births in the Third World by attacking the malnutrition, poverty, and medical ignorance that is the cause of this hidden plague, rather than lobbying against the rights of American women. Sister Donna Quinn, president of the National Coalition of American Nuns, says, "While we continue to oppose abortion in principle and in practice, we are likewise convinced that the responsibility for decisions in this regard resides primarily with those who are directly and personally involved. We are tired as women in society and in the Church to hear these decisions being made by men, politicians, and bishops, and not from the faithful and not coming from us as a group. You can't just make a law that forces consensus on a moral conscience issue." Catholics for Free Choice, a national pro-choice organization, says, despite all the vociferous rhetoric and lobbying of some other Catholic groups, such as the Right to Lifers, Catholics for Free Choice believe we have a majority of the Catholic people, who are really the Church, on our side as evidenced by the polls and by our mail. We abhor the irreligious concept that the state should own and control a woman's means of production, her body, at any time during her lifetime. We firmly believe that abortion is solely an individual matter of free choice of a female person, of minor or majority age, as a free citizen, in consultation with her medical advisor, and anyone else with whom she cares to consult, using her own conscience. We believe that no female citizen anywhere should be forced, under threat of criminality, by any governmental body, at any time, under any circumstance, to carry to full term a fetus, deformed or otherwise, against her own free will. Interference by the state would be a gross and unconscious full invasion of personal privacy and a violation of a female person's human, an inalienable right to choose or not to choose to responsibly control her own reproduction. To venerate the fetus above the life, health, and the religious and civil rights of the woman involved, to say that contraception and abortion are not ever allowed, when speaking of women, and at the same time to exalt celibacy for the patriarchal all-male hierarchy, thus preventing potential births, to approve of war, capital punishment, and killing of humans in alleged self-defense, when referring to males, is the height of hypocrisy. Christ himself uttered not one word equating abortion with murder, nor is there anything in the Bible forbidding contraception. Many truths of history are not taught in Catholic schools, such as that up to the year 1588, Catholic theologians and popes condoned abortion up to 80 days for the female fetus and up to 40 days for the male, although no one could tell the difference. In 1588, Pope Sixtus V forbade all abortions, and things remained that way for only 3 years, until 1591, when Pope Gregory IX rescinded that order and reverted back to allowing abortions up to 40 days for both the male and female fetus. The female fetus gained equality that year. This is how the matter stood until 1869, when Pius IV forbade all abortions at any times, and the doctrine of infallibility went into effect at about the same time. Roman Catholics for the right to choose believe that we are all Catholics, and many of us are totally opposed to abortion for ourselves. But we feel very strongly that we have no moral right to make this decision for others. As the late Cardinal Cushing of Boston said, speaking of birth control, Catholics do not need the support of civil law to be faithful to their own religious convictions, and they do not need to impose by law their moral views on members of society. What do we lose when we advocate a constitutional amendment by banning abortion? Well, first, we threaten our own religious freedom. We give government the power to pick one philosophy and use it as the basis for law. If others can be forced to live by our beliefs, could we too not be forced at some future time to live in a manner which violates our consciences? We strongly oppose establishment of any precedent for government to enter into what is essentially a deeply personal decision. We do not want a society in which childbearing is in any way a governmental decision. One sometimes wonders if the Church does not seek such a constitutional amendment to keep those of our faith in line, since Catholic women find themselves seeking abortion with at least equal frequency as do non-Catholic women. We talk about religion as the conscience of society, but we don't seem to act as though our position has had any moral force unless backed up by law. We think this issue is hampered by the confusion of a life and death ethic with a sexual ethic. We who are Catholic come from a church which is able to deal with killing under all sorts of circumstances. We have complex teachings on capital punishment, self-defense, just war, and so forth. Only in the area of abortion do we have an absolute prohibition in which circumstances are irrelevant. Could perhaps this relate to the old idea that pregnancy and childbearing are a woman's punishment for sexual intercourse? We urge the Senate to reject amendments banning abortion. When our church recognizes that special interest legislation cannot be achieved, perhaps when we can devote our full resources towards genuine pro-life progress, maintenance of a parochial school system for the Catholic education of our children and our doctrines, support for those with problem pregnancies, whether stemming from reasons of health, finances, or other crisis situations, and succor for the ill, the aged, and the incapacitated. Finally, Rosemary Radford Ruther, from the Roman Catholic theologian, Garrett Evangelical Theological Seminary, said, Americans need to be clear that the issue is not pro-life versus pro-choice. The issue is legal, safe abortion versus illegal or unsafe abortion. Banning abortion does not stop abortion. It merely makes it illegal and kills many mothers in the process. That same argument can be made for a 72-hour waiting period.
Thank you, Sister. I'm going to continue reading from Crow after Row and how we can change that. Under the Off the Sidelines umbrella, Kirsten Gillibrand had endorsed and raised money for long-shot congressional candidates such as Kathy Hochul, who won a special election in a Republican congressional district in New York in 2011, and Tulsi Gabbard, who was elected to Congress from the state of Hawaii in 2012, as well as numerous other state and federal candidates across the country. Kirsten is committed to helping empower women and girls to make their voices heard and make a difference in their community, says Todd Beaton, a spokesperson for Gillibrand. That's why she started Off the Sidelines as a call to action to women to get more involved in the issues they care about. Running for office is one aspect of that. Kirsten believes that if more women are elected to office and get a seat at the decision-making table, the outcomes will be better. Whether or not they have prior legislative experience, it is essential that candidates who support a woman's right to abortion and equitable health care be recruited to run. This means you. As we saw in the 2010 election, a large percentage of the candidates elected as representatives of the Tea Party had no previous electoral experience, and many even used that fact as a selling point in their campaigns. After being swept into office, these same legislators were responsible for creating the most hostile state environment to a woman's right to choose this nation has ever seen. Those Tea Party electoral victories would likely not have been possible, however, with a reasonable set of campaign finance spending and disclosure laws in place. Campaign finance reform and the problem of unlimited secret money flooding our elections is an issue of immediate importance for women's rights. In 2012, states enacted 122 new provisions related to reproductive health, including 43 restrictions on abortion access. The connection between big corporate election spending and anti-woman legislation is undeniable. In fact, it shares an architect, Attorney James Bopp, Jr. Bopp has served as vice chair of the Republican Party as well as general counsel for the National Right to Life Committee since 1978. His other high-profile anti-choice memberships include the unfortunately named Susan B. Anthony list and Focus on the Family. Bopp regularly testifies on anti-choice legislation, and his entire career has been built around promoting an anti-choice agenda and eradicating campaign finance reform. His goal is to shroud in secrecy the large dollar donors behind the efforts to criminalize contraception and outlaw abortion. And because of the persistency of the wage gap, women are not able to spend as freely in elections as are their male counterparts. According to the Center for Responsive Politics, even though women slightly outnumber men in terms of overall population, or they did at the time of the writing of this book, they accounted for only 29.6% of people making federal level political donations in the 2010 election cycle. That figure gets even smaller when you look at overall dollar amounts donated. Women contribute less money less often to political campaigns, and this is true even though the number of contributions by women is on the rise. As a result of this discrepancy in political donations, women's voices and interests are often drowned out. While focusing political efforts on electing women-friendly candidates is one way to fix the inequality riddling our system, once a law is on the book, it is much harder to reverse, even if the right candidates are put into office. It's for that reason that we need to focus also on judicial rather than just legislative means to effect change. As we've seen over the past few years, lawmakers in states hostile to women have no problem passing bills that may be unconstitutional, then leaving it up to the judiciary to make the final decision about whether or not the bill can actually become law. Organizations like the American Civil Liberties Union and the Center for Reproductive Rights are constantly filing suit against these bills. From 2010 through 2012, the Center for Reproductive Rights filed 20 different suits against anti-woman bills that had been passed and signed by Republican legislatures and governors. As a result, federal judicial appointments at the district court and appellate levels are just as important as the makeup of the Supreme Court when it comes to matters of women's reproductive health. As the end of As the end of 2012, there were 82 vacancies on the federal district and appellate courts, or a vacancy rate of about 10%. The nonpartisan Congressional Research Service recently determined that vacancy rates in the federal judiciary are at their highest levels in 35 years. In addition, over 40% of the existing vacancies are in courts so overburdened that they have been designated judicial emergencies by the Administrative Office of the U.S. Courts. Right now, we have an overburdened court system staffed by judges who are increasingly hostile to reproductive rights. It simply cannot be stressed enough how important the judicial branch is when it comes to ensuring an equal, fair, and accessible health care system for women. In the 2 decades following the 1992 ruling in Planned Parenthood v. Casey, the courts have yet to find a single case in which any law represented an undue burden on women seeking an abortion. Until a judge issues an official ruling that can be seen as setting a precedent as to what really constitutes an undue burden, Casey, in essence, can be used to do what abortion opponents have wanted ever since Roe was decided, which is to effectively ban abortion in nearly all circumstances by making it too difficult to access. Electing sympathetic politicians and continuing to fight unconstitutional laws in the courts are both important ways to level the playing field when it comes to women's health care. However, the most immediate step is to stop anti-abortion and anti-contraception bills from becoming law in the first place. Once it became clear that many of the conservative politicians elected in 2010 were actively engaging in a war on women's right to bodily autonomy, pro-choice forces began fighting back. Perhaps the best example of this is the fight surrounding 2 bills, one in Virginia and one in Idaho, that would have forced women to undergo an ultrasound prior to having an abortion, regardless of whether a provider deemed it medically necessary or not. After a spate of mandatory ultrasound laws were passed in states like Oklahoma and Texas, by the time a similar bill was proposed in Virginia, women were fed up. There was a Virginia Coalition of Women's Health that was formed, says Erin Matson, the former Action Vice President of the National Organization for Women. That was made up of local groups, and our local chapter, Virginia Now, was very supportive in that. Because we were close by, we supported some of the events that the coalition did out of our national office. One of the main events was a march on the state capitol demanding that the bill be shelved. Activists also began referring to the bill as state-sanctioned rape, because it mandated that if the abortion was to take place within the first 12 weeks of pregnancy, a transvaginal ultrasound had to be performed in order to obtain the most accurate, detailed picture possible. Since the majority of abortions occurred during the first 12 weeks, the rule would have applied to most abortions performed in the state. The state-sanctioned rape framing caught fire among women's rights activists. Virginia Delegate David England, a Democrat, said that if the bill was approved, it would essentially turn the doctor who performed the ultrasound into a criminal under the definition of rape in the Virginia Penal Code. Object sexual penetration is a new issue I plan to raise when we debate the Senate version of this bill next week, England told Andy Kopsa of Reality Check. But surely, decent people who disagree about a woman's right to choose can at least agree that she shouldn't be vaginally penetrated without her consent. That's a moral outrage that every decent person should oppose, regardless of partisan politics. Worse still, it appears that if the lack of any consent requirement would turn doctors into criminals by compelling them to commit object sexual penetration, which is a heinous sex crime under Virginia law. While the bill ultimately passed in early 2012, the forced transvaginal requirement was dropped, replaced by the more traditional abdominal ultrasound, a small but not insignificant victory for pro-choice forces. Virginia Governor Bob McDonnell and his fellow anti-abortion lawmakers had presented the transvaginal ultrasound as a necessary part of informed consent, arguing that if a woman didn't know the size of the fetus or embryo and wasn't certain of the exact date of conception, she somehow didn't have enough information to make an informed choice to terminate her pregnancy. By changing the transvaginal ultrasound requirement to the abdominal version, despite medical evidence that for most women early in pregnancy, the images would hardly be recognizable, it became clear that informed consent was never the goal, but that the purpose of the law was to set up a roadblock to abortion access.
That's it. I
Hi, my name is Mandy Laddie, and I'm going to finish my section of filibustering today. Before I pick up where Sue left off, I'd like to address a popular moral argument against abortion. Opponents of abortion often argue that the my body, my choice argument only makes sense when someone else's life is at stake. And that's just not true. For example, if my younger sister was in a car accident and desperately needed a blood transfusion to live, and I was the only person on earth who could donate blood to save her, and even though donating blood is a relatively easy, safe, and quick procedure, no one can force me to give blood. Yes, even to save the life of a fully grown person, it would be illegal to force me to donate blood if I didn't want to. We have this concept called bodily autonomy. It's this cultural notion that a person's control over their own body is above all important and must not be infringed upon. We can't even take life-saving organs from a dead corpse, unless the person whose corpse it is gave consent before their death. Even corpses get bodily autonomy. To tell people that they must sacrifice their bodily autonomy for 9 months against their will and in an incredibly expensive, invasive, and difficult process to save what you view as another human life, a debatable claim in the early stages of pregnancy where the vast majority of abortions are performed, is desperately unethical. You can't even ask people to sacrifice bodily autonomy to give up organs they aren't using anymore after they have died. Opponents of abortion are asking people who can become pregnant to accept less bodily autonomy than we grant to dead bodies. And now I'll pick up where Sue left off. The fight over the bill also took its toll on McDonnell and his allies. After the bill passed, polling showed that over half the state disapproved of the mandatory ultrasound requirement. McDonnell's popularity went down 5 points, and the state legislature's popularity went down 10 points. These lawmakers grossly underestimated the outrage their insidious attacks on women's health would provoke in Virginia and across the nation. Tarina Keene, executive director of NARAL Pro-Choice Virginia, wrote in April 2012, "In fact, their agenda awakened the sleeping giant of pro-choice Virginians. The majority of citizens who believe the government should stay out of women's private medical decisions and personal family choices. With this spring awakening will come retribution at the polls this fall and in the fall of 2013. Aaron Matson agrees that what happened in Virginia was a sign of an awakening. I don't agree with the idea that women took reproductive rights for granted, she said. When you grow up having access to birth control and access to reproductive rights, you have every right to expect that it will still be there. Now that these attacks are coming on their own terms, I think that they are being experienced on their own level. We are seeing a new awakening, but when I say awakening, I don't mean people were sleeping. Women had every right to expect they wouldn't be harassed this way. That's not taking something for granted or being unaware. We have the right to be treated as full people. Idaho Senate Bill 1387, which was proposed by Republican Senator Chuck Linder, would likewise have forced women to undergo an ultrasound prior to an abortion, regardless of whether or not doctors deemed it necessary. However, Linder also included a requirement that the State Board of Health create a list of healthcare providers, facilities, and clinics where a woman could receive a free ultrasound, a group that would be made almost exclusively of crisis pregnancy centers. Unfortunately, many, if not all of the centers, didn't have the proper equipment to provide the diagnostic images the law required. The bill also stated that the ultrasound had to be performed by the same physician or an agent of the physician to perform the termination, neither of whom were likely to be someone at a crisis pregnancy center. When it was explained to Linder that the pregnancy center ultrasounds might not meet legal requirements, he seemed unconcerned, saying that the purpose of the bill was to stop women from having abortions. This open, brazen admission that the bill had nothing to do with health care and was just an attempt to convince women to forego their legal right to terminate a pregnancy angered the people of Idaho into action. The day the Senate debated the bill, a Boise woman showed up with a petition with over 4,000 signatures asking that the bill be killed. People in and out of the state also used social media to put pressure on Linder, other key legislatures, and even the governor, asking them to table the bill. Hannah Brass-Greer of Planned Parenthood Votes Northwest recalls, "We had a number of volunteer phone banks with emails flowing into targeted legislators. We had a middle-of-the-week midday rally with over 300 people showing up. But despite the public pressure, the Senate voted the bill through. Yet even with mounting protests from anti-abortion activists who went as far as to perform live ultrasounds in the state capitol to prove that women love undergoing the procedure, the bill never received a hearing in the House because of the counter-pressure from pro-women activists. Opponents of the bill filled the hearing room as the bill was being debated in the Senate, then followed up with letters, phone calls, and emails that drew the attention of the local and national media. This was my sixth session of the Idaho legislature, and I had never been involved in a fight against the bill that had so many people come to the legislature, making phone calls, coming to vigils, to call it Brass-Greer. We don't often have a lot of victories. This is a lesson in not discounting the community you are working in, and not assuming what will and won't get people fired up. There's some sort of changing of the tide. People that didn't focus on these issues before are focusing on them now, both nationally and in the Senate. We need to fight against all of these bills with the same intensity each time. A lot of times you might lose, but sometimes you win, and you win really big. As the examples in Virginia and Idaho demonstrate, activism can prevent anti-women legislation from passing, or at the very least, keep it from being as burdensome as it might have been at its implementation. However, even in cases where it is obvious that a bill will pass, a large public outcry can change the tone of the debate and have some effect, regardless of how little it may change the result in the end. For example, it was assumed that once Georgia Representative Doug McKillop proposed the 20-week post-fertilization fetal pain ban in 2012, the bill was given for passage. Instead, the bill was nearly torpedoed due to fracturing within the anti-choice community when the state Senate made a modification in response to pressure from pro-women groups. When McKillop's bill was originally introduced in the Georgia House, it provided absolutely no exceptions to the ban on all abortions after 20 weeks fertilization. Medical experts testified against the bill, noting that abortions after 20 weeks are almost exclusively due to with the fetus, a fact that McKillop repeatedly disputed without evidence. After Dr. Andrew Dott testified that in all of his years of practicing medicine, he had never had a patient choose to have an elective abortion after 20 weeks, McKillop called him a liar, saying the doctor was making up stories to kill the bill. Jay Bookman of the Atlanta Journal-Constitution reported, contradicting Dott, McKillop insisted that the grand majority of abortions performed in Georgia past the 20th week are abortions of convenience, but again he cited nothing more than his own considerable moral certitude as evidence. Despite the emotional testimony, the House refused to allow an exception for medically futile pregnancies, demanding that women carry all pregnancies to term even if doctors tell them that the baby won't survive outside the womb. In response, angry activists flooded the state capitol, where they were joined by the female Democratic delegation, all of whom opposed this intrusion into women's private lives by the mostly male state government. The Senate, trying to find a way out of a situation that had morphed into a political hot potato, amended the bill to allow terminations when the fetus was found to be non-viable. McKillop and his cohorts were so angry at the modification that they nearly threw out the entire law. It was only after extensive negotiations, including an explicitly minimalistic definition of what constitutes a medically futile pregnancy, that the new bill was voted into law. Although the ban made it into law, it wasn't the version that had been initially introduced, and it passed with activists chanting, "We will remember," outside the chamber doors. At the same time, the Democratic delegation turned their backs on McKillop as the votes were cast. In the end, a nearly guaranteed victory for anti-choice politicians instead became the mixed bag of success and failure. And more importantly, the public perception of the debate shifted drastically as a result of the actions at the state capitol. The bill was then challenged by the ACLU Foundation of Georgia and is currently blocked from being enacted. In the end, if there is a silver lining to the anti-contraception, anti-abortion, anti-women laws that have passed or been enforced since 2010, it is that they have created the beginnings of a powerful activist backlash. This backlash has in turn shown that with concerted planning and effort, the decades-long erosion in women's health care rights may yet be reversed. I think one of the really heartening things that we've seen this year is the extent to which women are standing up and saying, "Enough of this crap," says Michelle Lovehead of the Center for Reproductive Rights. We are in the middle of a new Anita Hill movement when it comes to reproductive rights at Huntington. Just like Anita Hill used the horrific way to which she was treated and galvanized women to run for office, I sincerely hope that we will see a longer-term infusion of more women ready to stand up for reproductive rights. While Matson admits that there are still dark, dark days for reproductive rights, in this darkness she can see rays of light. In these dark days, I actually have a lot of hope, she says. Activism is at a different level right now. Awareness is at a different level right now. People ask, where are the women? And let me tell you that they are here right now fighting back against these right-wing assholes. I don't see that going away. I only see it growing. I do feel paradoxically at this horrible time a lot of hope about activism and feminism and the reproductive justice movement. We can use the 40th anniversary of Roe v. Wade to reaffirm the principle that a woman's right to control her body supersedes the right of the state to mandate how her body is used if she is pregnant. The first 4 decades after Roe has been slowly whittling away the rights of women that were established by that ruling. Now it's time to dedicate ourselves to making the next 40 years about gaining those rights back for every woman and girl in this country. At this time, I'd like to read some stories from some women who were brave enough to offer their own stories. Choosing inspiration. That's how I think of my own experience of abortion. Not that at the time, or even now, did I ever really consider having a child. I myself was still a child at 17 when I found out I was pregnant. I still am in many ways. Of course, I knew of the controversy surrounding the issue, and I had seen it firsthand every month when I went to buy my pill pack from the local Planned Parenthood, local being a 45-minute drive one way. I had always sympathized with the other women who had to endure the ridiculous and unnecessary behavior of the angry people on the sidewalk, who had nothing better to do with their time than hold deceitful pictures of bloody fetuses, nothing at all like what a first trimester fetus would look like, and scream their scriptured propaganda. It enraged me that they lacked the human decency to let a woman walk from her car to the door unmolested when they could have no idea why they were there. When it was my turn to be that woman showing up for her appointment, the man on the sidewalk with his bullhorn seemed to me to be the most horrible human on the planet. Could he not see how young I was? That I couldn't even fix the busted front of my car, much less provide for a baby? Apparently not, because he yelled anyway. Sitting in the waiting room with 6 other women who were there for the same procedure as I was struck by the diversity of our group. A few were like me, and didn't even look like they should be out of high school, much less having a baby. One woman had her toddler with her, and others looked to be in varying stages of life and social economic status. We traded shy glances and awkward conversation until the mother of the toddler broke the tension by saying, "Well, everyone here can see why I'm here. I thought that Eddie outside was going to have a coronary." We all laughed and responded with, "I knows," and "What a jerks." I think we all felt relieved that regardless of reason we had made the same choice, and were not alienated here in the waiting room like we had been walking to the front door. This experience and everything that followed inspired me to change my mind, my awareness, and my life. I'm now married to the same boy I was then, my first and my only, my best friend. My life is driven by my passion for women's care. I am in school to become a certified nurse midwife and am determined to move to a state where I can get my license to provide abortion services. My dream is to have my own practice and to give women a warmer, more personal experience of family planning. I absolutely cannot wait to bring on the future. From Ryan, 20 years old. Rob, who is 60. My mom was born in 1911. She was ahead of her time. The one issue that mom was quite adamant about was abortion. I was confused. Mom was nuts about babies. She was an OBGYN nurse. She worked in the delivery room at one time. I had to ask. Mom said, yes, there are better choices that could have been taken, but they weren't. What we have to do now is protect life through safe clinical procedure. You see, I didn't know what mom had seen over 30 years worth of results of botched illegal abortion. My mom is gone now. I will not let what she fought for be trampled into the ground, and this is why I stand with you brave women. I have big shoes to fill, but I will do my best. Carolyn, 18 years old. My freshman year going into college, I found out I was pregnant. I talked to only my mother, father, and sister about what my choices were. I was scared and felt absolutely alone at college. It was only the third week of being there, and I had already had trouble adjusting anyway. When the option of abortion came about, I thought that I was pro-choice, and I could not tell a woman it's wrong for her to get an abortion. But it wasn't for me. I never thought I'd be in this position though, and that changed everything. I wanted to go to college, learn. I had a plan, and even physically being pregnant, I decided to take away some of my experience. So with the support of my mother, who had had an abortion when she was a little older than me, and my father, I made the choice to have an abortion. Now I was afraid to tell almost any peers back home, even some of my closest friends. They would have criticized me greater than any protester outside the clinic the day my procedure could. I am pro-choice. For every teenage young adult woman who is afraid to voice her choice because of how politics and religion has influenced her peers. For every girl who has been the only one brave enough to say their pro-choice in a classroom debate and take the verbal abuse from not only her classmates, but even the teacher. I am pro-choice because I've realized no one should have to be afraid to admit something that is her right. Rachel, 24. During my college career, my best friend was an advocate for women's reproductive health. She constantly volunteered at the Feminist Women's Health Center in Atlanta, joined pro-choice rallies, and petitioned her legislators. I admired her determination and yet did nothing myself. Until recently, I did not internalize how crucial the role she plays in reproductive health. Today I had an abortion. Today I had to drive 3 hours out of my home state to obtain an abortion because the laws in my state are so restrictive that my choices were limited. Today I understand why Sarah does what she does. And today, I signed my first petition. Stacy, 39. When I was in high school, my mom took me to my first rally in Washington. At the same time, she discussed birth control, abortion, and the struggle that women went through to have the right to control their own reproduction. She made certain that I was well educated, and even when I went to college, I made certain that I escorted women at clinics and volunteered at NARAL to ensure that we would always have the right to choose. I was taught that you had to be vigilant because there were people that could take this right away. I was on birth control and assumed that I would never need to use the right to because of precautions. Well, I became the 1% statistic that gets pregnant on the pill. I was living in Chicago at the time and called my mom immediately. She flew up here to be with me, and the clinic that I went to was wonderful. I am truly grateful that this option was available to me as I was 21 years old and completely incapable of raising a child. I can't imagine where my life would be if I had been forced to have a baby. I'm grateful to my mom most of all, and to all the women who have fought and continue to fight to ensure that I have the right to choose. Thank you. Renee. The day the appointment came, I was very scared. My parents went with me, and as we were driving into the parking lot, a man came to the car and threw a poster on the windshield so that we couldn't see where we were going. Nice for a pro-life person to try and make us crash, huh? As I got out of the car, there were maybe 10 men that started yelling things at me. I was a killer. Then they took it to a new level and started to throw big rocks at me. I found this so strange because I was always told that pro-life people wanted to protect life, not hurt it. But they didn't care. They kept throwing rocks and yelling things. My dad actually had his head between his side and his arm because they were trying to hit me in the head. I got in and talked to the nurse about my decision. I was there for about 3 hours before the procedure took place. This is not a religious issue. It is a health issue. For anyone to think that making this decision was really easy is just wrong. But it was the best decision for me, and it was my decision, and if I had to do it over again, I would. I will fight for the pro-choice movement until the day that I die. Natasha, 27 years old. When I was a teenager, my mother told me that she had an abortion when she was my age. She said the decision was a very hard one and that the aftermath had been difficult, but she said that act had changed her life. Without the freedom to decide what happened to her own body, her life would have been a very different one, and she wouldn't have had me. I am pro-choice because abortion rights allowed my mother to make the most important decision of her life on her own, with privacy and dignity. Now I'll read a study of reproductive outcomes. Researchers have examined the impact of mandatory counseling and waiting period laws on a number of reproductive outcomes: abortion rates and ratios, birth rates, the proportion of abortions among state residents performed out of state, and the gestational age of fetuses and abortions. We examine researchers' findings in the context of their work and provide detailed information on the full requirements of the law and the state of interest for each study that focuses on individual states. The specific requirements of these state laws are constantly reinvented or reinterpreted. It is important to note that many changes in the laws may have occurred since these articles were published. Reproductive outcomes among women of childbearing age. 6 studies evaluated changes in abortion rates and ratios following the implementation of mandatory counseling and waiting period laws. 1 study also assessed the impact on birth rates. 4 studies analyzed changes in the timing of abortion, and 3 examined the impact of laws on changes in where abortions occurred. 4 of those 6 studies found a statistically significant association between mandatory counseling and waiting period laws and abortion rates. 3 of these studies focused on Mississippi. The studies are presented chronologically. 2 studies, which are presented last, found no impact on these laws on reproductive health outcomes. Alphas and Hinshaw examined detailed abortion data from the Mississippi State Department of Health Division of Public Health Statistics to determine the effect of the state's 1992 mandatory counseling and waiting period law on abortion trends. The researchers used state-collected information on residents who had abortions in Alabama and Tennessee to examine the effect of the law on women traveling out of state. The bordering state of Louisiana does not collect abortion data on out-of-state residents, and the authors did not gather data from Arkansas. Typical of other mandatory counseling and waiting period laws, Mississippi statute required that a woman be given information at least 24 hours prior to the abortion regarding the name of the physician who would perform the procedure, the medical risks associated with the abortion, the probable gestational age of her pregnancy, and the medical risk of continuing her pregnancy. In addition, a woman was required to be informed about medical assistance benefits available to her if she continued the pregnancy, the father's liability for child support, the availability of pregnancy prevention services, her right to review state-produced materials that listed services to assist a woman through pregnancy and childbirth, and a brochure that described fetal development. All of this information had to be delivered by the referring physician or the physician performing the abortion. In Mississippi, the law requires a woman to hear the information in person, which clinics have interpreted as face-to-face. This necessitates 2 in-person visits to the clinic. In a before and after analysis of state-level abortions, the researchers found that the actual number of abortions performed in Mississippi was 22% lower than expected based on previous years. They also found that the number of abortions provided to non-residents fell 30%, while the number of Mississippi residents who obtained an abortion in Tennessee or Alabama increased by 17%. Overall, the researchers concluded among women who have had abortions, the law prevented approximately 11 to 13% of them obtaining one. The law was also associated with women having abortions later in pregnancy. The proportion of Mississippi women who obtained an abortion after more than 12 weeks of gestation increased by 17% in the 5-month period after the law was enforced, compared with the 7-month period prior to enforcement. In addition, the decline in abortions was greater for women with less than 12 years of education than for more educated women. This was the first study to use data on abortions to evaluate the impact of mandatory counseling and waiting period laws. A strength of the study is its use of abortion data by state of residence. The data show that not only did women leave the state to obtain an abortion, but fewer women came into the state for an abortion. The major limitation of the study is the lack of a control group other than the Mississippi in the months before the law took place. Although the number of abortions fell sharply in the months, right after the law's enforcement, abortion might have fallen somewhat in the absence of the law. Thus, we don't doubt that the waiting period requirement had a statistically significant effect on the number of abortions in Mississippi, but the exact size of the decline is uncertain because of trends in abortion that may have existed prior to law. Joyce, Henshaw, and Gattred extended the work of Althus and Henshaw by analyzing the effect of Mississippi's mandatory counseling and waiting period statute on abortion rates and birth rates, as well as on the timing and location of abortions for the period from 1989 to 1994. They used Georgia and South Carolina as comparison states, since neither state enforced a mandatory waiting period during these years. This enabled the researchers to use a difference in differences methodology. The authors also estimated a regression model using monthly abortion rates in the 3 states over this period. The authors reported that the abortion rate in Mississippi jumped by 16% in the year following enforcement of the mandatory counseling and waiting period law. In the same period, the abortion rate fell by 5% in South Carolina and by 3% in Georgia. Thus, they estimated that Mississippi's law was associated with a 12 to 14% decline in abortion rate among residents. The authors concluded that they likely overestimated the decline since they lacked data on Mississippi residents who obtained abortions in Louisiana. To adjust for this, they estimated the likely number of abortions that residents obtained in Louisiana based on that state's 1988 data. After adjustments, they concluded that Mississippi's mandatory counseling and waiting period law was associated with approximately a 10% decline in the resident abortion rate. The authors...
Fellow Missourian asked.
Yes.
Hello, my name's Wilson, and I'm a student at the University of Missouri. I'm a citizen of Mississippi County. I'm here today because I'm displeased with the way the state is addressing issues of women's health. I'm going to be reading from a book called The Religious Case for Abortion. I'm going to start with chapter 4, Protestant Perspectives. The American Baptist Churches of USA say, because Christ calls us to affirm the freedom of persons and the sanctity of life, we recognize that abortion should be a matter of responsible personal decision. From the United Methodist Church, because human life is distorted when it is unwanted and unloved, parents seriously violate their responsibility when they bring into the world children for whom they cannot provide love. When an unacceptable pregnancy occurs, a family, most of all the pregnant woman, is confronted with the need to make a difficult decision. We believe that the continuance of a pregnancy which endangers the life or health of the mother or poses other serious problems concerning the life, health, or mental capability of the child to be is not a moral necessity. In such a case, we believe the path of mature Christian judgment may indicate the advisability of abortions. We support the legal right to abortion as established in the 1973 Supreme Court decisions. We encourage women in counsel with husbands, doctors, and pastors to make their own responsible decisions concerning the personal or moral questions surrounding the issue of abortion. Lutheran Church in America says, on the basis of the evangelical ethic, a woman or couple may decide responsibly to seek an abortion. Earnest consideration should be given to the life and total health of the mother, her responsibilities to others in her family, the stage of development of the fetus, the economic and psychological stability of the home, the laws of the land, and the consequences for society as a whole. In the United Church of Christ, the theological and scientific views on when human life begins are so numerous and varied that one particular view should not be forced on society through its legal system. United Presbyterian Church in the USA, women should have full freedom of personal choice concerning the completion or termination of their pregnancies. The full personhood of the woman is of importance to the religious community. She must make the ultimate decision about her pregnancy, for she will bear the ultimate responsibility for that decision. From Teresa Hoover, the Associate General Secretary of the Women's Division of the United Methodist Church, in testimony before a congressional subcommittee. Women are recognized as created, loved, and loving human beings who have achieved full personhood. In sight of most Protestant denominations, to equate personhood with an unborn fetus is to dehumanize a woman, to consider her a mere thing through which the fetus is passing. To deny this essential tenet of our beliefs, the concept of personhood, would constitute a gross violation of our Christian faith. Women suffering from heart disease, diabetes, or cancer could suffer grave, if not fatal, risks if she continued a pregnancy to term. A woman who is the carrier of a genetic disease such as sickle cell anemia or Tay-Sachs, which may be transmitted to the fetus, should not be compelled to bear that fetus if she does not choose to after medical tests have confirmed the fetus is affected. We cannot in good conscience force a woman who has been raped to carry the possibly resulting pregnancy to term. To do so would be to totally disregard the anguish which women suffer in such circumstances. We recognize that a woman rightfully has hopes and concerns in her life which do not and cannot include an unplanned pregnancy. While there are several alternatives which she may explore in the event such a pregnancy occurs, we believe that abortion should be one of the choices available to her. She should choose abortion, safe, legal abortion. Should she choose abortion, safe, legal abortion services are her right. From Elizabeth Miller, Secretary of Issue Development, National Ministries of the American Baptist Churches of the USA. There is no particular point at which it can be said that an embryo or fetus becomes a full human person. Rather, the fetus is in the process of becoming a human, while the fetus has the potential of becoming human is only the potential. The woman who is carrying the fetus has a full human being and also usually has much potential for growth and development in her life. For some, that potential may be fulfilled by continuing the pregnancy to term and bearing a child. For other women, the continuation of pregnancy will deny, stifle, or warp their potentials. To insist on developing the unknown potential of the fetus while denying the woman the right to make a choice about her own life and her potential is a denial of her personhood. We'll move on now to chapter 6, a physician's testimony. Dr. George Ryan, president of the American College of Obstetricians and Gynecologists, made the following points in his testimony before a Senate subcommittee. Question asked of him, what is the position of the American College of Obstetricians and Gynecologists on the Human Life Bill, which declares that human life shall be deemed to exist from conception? The answer, we are opposed to the bill for the simple reason that it would present great difficulty for obstetricians and gynecologists to provide health care to women who are pregnant. The bill assumes that every fertilized egg would go on to normal pregnancy if it were left alone. That's not true. We see many tubal pregnancies and abnormalities in the development of the egg inside the womb. Some of these become cancer. Question. Do you believe life begins at conception? Answer. Biological life, yes. Human beings, no. For example, a woman who has a husband and 2 children ends up with a pregnancy in her womb. This can threaten her life. Some legislators are saying that these few cells in her tubes have all the rights that her entire family has and that we must jeopardize the woman's life. To me, this is nonsense. Question. But do you agree that life begins at conception? Answer. There is no question that a cell is living, but life is one thing, and when it should be considered human is not a scientific question. It is philosophical, moral, and theological. All these years we have said a human is entitled to the rights of the Constitution at birth. This has worked pretty well so far. Question. What economic effect will this bill have on these women? Answer. If abortions are made illegal, it means at least another 700,000 babies will be born next year. A substantial percentage will be born to the poor and the very young, about 2/3 of whom will collect welfare. Instead of a single cost of $125 for an abortion, we will pay $1,000 to $1,500 for a delivery and at least $100,000 to support these welfare children until they reach maturity. This is a commitment of about $40 billion a year. Question. Some senators and congressmen say the cost doesn't matter, it is worth the price to save lives. Answer. The same people who want to save those babies are unwilling to give them food stamps. They don't care if the babies live in roach-infested houses. They don't care if they get adequate schooling. It's a strange contradiction that the people who say they want to save lives have so little compassion for people after they're born. I'm more interested in the people who are already here. Moving on to chapter 7, Watch Out for Saints by Paul Rhodes. The so-called right-to-life people are intensely concerned with the fetus, but once it comes out of the womb, they are unconcerned. How many right-to-lifers have you seen working in the slums to reduce poverty and child abuse? How many right-to-lifers have you seen working to stop war and famine throughout the world? What compels these zealots is a melange of twisted emotions, including the following. 1. Hatred of women. Many of the zealots view women as temptresses who lure men into sexual intercourse. If they get pregnant, well, it serves them right. It's just a punishment they deserve. 2. Sexual envy. While the zealots struggle to contain their own sexual urges within the bounds specified by their religious leaders, they become jealous and enraged when they see other people, especially the poor, indulge in sexual freedom. The right to lifers would deny all this, of course, because they're not in touch with their real emotions and motivations. They convince themselves that all they care about is the sanctity of human life. Watch out for a religious person who says he's convinced he's a saint. He will make your life miserable and maybe even someday kill you. French Catholic philosopher Pascal wrote, "Man is neither angel nor beast, and he who would presume to be an angel ends up becoming a beast." In our own time, we have seen how self-styled holy men, such as the Ayatollahs of Iran, claim to be the saints and end up killing those who disagree with them. The right to lifers claim to be doing the work of God, and this arrogant self-righteousness drives them to commit evil in the name of God. If Jerry Falwell and Jesse Helms, two men who claim to be carrying out God's instructions, succeed in making all abortions illegal, will inflict enormous suffering upon women and children. Countless thousands of women will be killed or maimed by back alley abortionists. Countless thousands of children who are born unwanted will grow up unwanted, and even eventually crowd out prisons and welfare wills. Watch out for a man who claims to be a saint, for he will end up becoming a beast. In 1981, Senator John East, a fanatical anti-abortionist from North Carolina, who has undertaken a religious crusade to ban all abortions in America, was chastised in a Senate hearing by his fellow Republican, Senator Bob Packwood of Oregon. He said, "I would suggest to you that it's not only unwise but unworkable to try to impose your idea of morality on this country by legislation when there is no agreement on your conclusions. Every generation witnesses a new group of citizens who believe themselves the keepers of the faith. It is not a disease unique to America. The difference is that in America, we have seen and experienced the dangers of moralists who are so convinced that they are right that they choose to impose their morality on us. God did not speak to any one of us and say, 'You are right, and those who disagree with you are wrong.' If any one of us thinks that God ordained us to speak for him, we are wrong. Worse, if we are in a position of power, we believe we speak for God, we become dangerous." Chapter 8, quotable quotes. Listen with the psychoanalyst's third ear to those who want to use a pregnancy as a punishment, and you will hear loud and clear the throttled voice of sexual envy. Dr. Gary Hardin in Mandatory Motherhood. Forced motherhood cannot be the basis on which a democratic society can function effectively. Over the centuries, only tyrannies have insisted that women must bear children as a duty they owe the state. William P. Thompson, Chief Executive Officer of United Presbyterian Church, USA. Any pro-lifer who hasn't adopted at least one child more than he is financially or emotionally capable of caring for should keep his opinions to himself, says Allie Rosie in Detroit. The Right to Life activists claim that they are working to strengthen the family. Does a 14-year-old child on welfare with an unwanted child constitute the kind of family they have in mind? Says Margaret Close, Keene, New Hampshire. Anti-abortionists pose the question, what if Einstein's mother had had an abortion? I ask, what if Hitler's mother had had one? Says Pamela Brown, New York City. What are we to do when the continuation of a pregnancy will obstruct God's loving intentions for existing human beings? What about the 12 or 13-year-old child who becomes pregnant? What about the women whose health may be placed in jeopardy by the continuation of a pregnancy? What about the case of rape and incest? What about the fluke pregnancy of a person of advanced years? What about the pregnancy in a family that already has too many children for proper care? Should our concern for the potentialities of a fetus, prior to the dawning of its awareness of personhood, override the claims of love in these and similar human circumstances? J. Philip Wagaman. If anti-abortionists prohibit abortion, they will be responsible for untold human misery. They will be responsible for lessened enjoyment of sex, for frustration caused by inconvenient pregnancies and childbearing, for ill health, either physical or mental, of mothers and other persons, for deaths of women resulting from pregnancy and illegal abortions, for child abuse, for claims committed by frustrated or improperly socialized individuals, and for the stunted life of everyone if overpopulation seriously curbs our freedoms and lowers the quality of life. This yours? The ardent anti-abortionist must shoulder the burden of the responsibility for these things. The so-called right to lifers can accept with us that any number of poor and largely ignorant women who will go to neighborhood coat hanger abortionists to save money. God is punishing them for their sins, and our legislators can deny abortion funds to indignant women because they can easily afford safe and legal abortion for their own wives and daughters. Justice William J. Hellman. It is our hope that Catholic women will throw off the needless mantle of guilt and recognize that they alone are capable of weighing the conflicting values inherent in the abortion decision, and that they are full human, moral, and ethical beings. Patricia McMahon. Should a male-dominated religious hierarchy of the Catholic Church determine the moral posture and legal status of the opposite sex? The question is caught up in a dilemma no man can fully understand. A church that proclaims celibacy to reflect the highest level of excellence and that takes the dimmest possible view of scientific methods of birth control is not in a logical position to impose its views on abortion on the remainder of the citizenry. We should have learned our lessons. More than 50 years ago, a Protestant Puritan mentality sought to write a particular view of moral responsibility and personal behavior into the Constitution of the United States. Prohibition resulted, and it failed. Ours is a pluralistic society. Any attempt to write one particular religious viewpoint into a law seems a violation of the liberty guaranteed by the Bill of Rights. As Bishop A. James Armstrong of the United Methodist Church. The connection between personhood and birth undoubtedly comes from the second chapter of Genesis, which states that man became a living being when God breathed into his nostrils the breath of life. In other words, personhood exists when a child is able to breathe on his or her own apart from the oxygen delivered through the uterus. Protestants generally do not believe the human person is present at conception. The soul is not infused. Instead, the fetus is a potential person. The mere fact of conception does not mean that God wills a childbirth. The occurrence of a miscarriage or stillbirth suggests that every conception is not intended to result in the birth of a baby. The new right is attempting to re-empower an old wrong. The concept that a woman's pregnancy is more important than women's rights. This barbaric notion reduces women to solely biological status. She is more breeding stock than person if a baby-to-be takes a legal precedence over a woman that is. It is at once the glory and the burden of each of us that we are called upon to make such difficult personal decisions according to our consciences. When we deny that liberty to any one of our number, we give away a part of our own birthright. When, more specifically, we condemn a woman for making an independent judgment according to her own conscience, relating to her reproductive life, we denigrate her personhood. The rightness or wrongness of abortion as the solution of the problem of pregnancy is not the critical issue here. The issue is the larger ethical one. Can any one of us stand in the role of judge for the personal decisions of others? What robes shall we wear? Greater than the debatable immorality of terminating an undesired pregnancy is the immorality of refusing a woman access to medical help when she has determined that she needs it. I believe abortion is a very serious moral matter, but I believe in freedom and responsibility, and thus the woman must be given the opportunity to make the decision. Opponents of abortion sometimes argue that a fetus wants to grow up into a real person, but every egg and sperm also want to become a person in this sense. And if that's the case, how can one defend either contraception or celibacy, both of which deny life to millions of eggs and sperms that want to become pregnant? Anti-abortionists claim that legal abortion will lead to euthanasia for senior citizens, followed by flat-out genocide. This argument is intended to drum up support by raising the specter of Nazism, but the reasoning is backward. The threat of such atrocities lies not in granting women the freedom to terminate their own pregnancies, but in granting governments the totalitarian power to tell them that they cannot. Chapter 9, Abortion, 1954. If abortion is once again made illegal in the United States, thousands of women will seek the back alley abortionists. Lest society forget the terrible days prior to the 1973 Supreme Court ruling, Sherry Matulis gives a courageous, heart-wrenching account of what happened to her in 1954. This article, which first appeared in Progressive magazine, was reprinted with the permission of the author. I get it all the time, from nearly everyone I know. Why did you do it, Sherry? They ask. Why make things difficult for you to stop? I mean, my lord, at your age, you certainly don't have anything to be concerned about. The it that I do, the thing I'm getting all this good unsolicited advice about, consists of campaigning for freedom of choice in all aspects of life. But now, especially regarding abortion. And they're right, of course. I do deliberately put myself between the rock and the hard place, as often as vociferously as possible. And they're also right about not having anything to be concerned about, so far as the possibility of my ever becoming pregnant again. But there was a time. I was 23, pleasantly married, the mother of 2 planned for and well-loved children. The number later grew to 5, and working nights at a cocktail joint. One night, I got off the 1:20 a.m. bus and started my usual trudge home, cutting the 3 blocks to 2 1/2 by what we called the schoolyard shortcut. I remember the moon was full. I remember thinking, the full moon brings out flakes and fruitcakes, and there had been plenty of them that night, grabbing and groping at the bar. I remember thinking how not too many moons distance I would be in a home of my own, a place with decent plumbing and a yard full of kids, the place I'd been working for between babies for years. I remember whistling, not out of fear but out of happiness. And for a long time thereafter, that was all I remembered. It was all I could bear to. He must have been waiting close to the building in the shadows. I didn't see him until he was on top of me, and I still remember very little about the action itself. Not because I'm trying not to any longer, but because when he threw me back on the blacktop, my skull cracked and I blacked out. One merciful concussion, and a couple hours later, I was staring at the moons. Yeah, both of them. Both full. And all I could think was, well, no wonder. What else with 2 full moons? The back of my head was sticky red. Blood, lots of it. Most of my clothing had been torn off and scattered. As I tried to get up and retrieve it, I felt a terrible, searing pain in my midsection. Like a knife, I thought. Like, looking down, I saw this odd, ugly mass of something perched on my abdomen. It took at least a minute to realize it was part of my intestine. The knife was no longer there, but it had been, just oozing out of a neat X. Holding both hands against something I hope to never feel again in my life, somehow I managed to get up, somehow I managed to get home, and somehow with a lot of tutoring and a couple weeks of intensive care and an infinite amount of love from a husband who rushed home from 3 states away and never left again, I managed to survive. Only to find myself wishing about a month later that I hadn't. I was pregnant. I was not pregnant by my husband. I was pregnant by that fiend. And I could not stay that way. My doctor would not help me, so I feigned migraine to get a prescription of ergotrate, which I think gave me a migraine. I went on a 2-day castor diet and lost 5 pounds in a quart of hemorrhoidal blood and nothing else. I scalded the lower 2/3 of my anatomy squatting in hot tubs. I detested the taste of alcohol, but I held my nose and down 2 pints of Everclear. When I woke up, everything intact, I got out the meat now and began pounding my almost healed abdomen. My husband was ready to stick me in a straitjacket. He wanted me to go through with the pregnancy, or rather, he wanted me not to kill myself, or be killed by the only sort of abortions that was available at that time. He thought that once the baby was born, we could both accept it as our own. And the good person that he is, he probably would have tried. But I could not ever. I knew that I had given birth to a child conceived under those circumstances, and I would not be able to look at it without remembering. And remembering would mean hating all over again. I wasn't willing to put myself or a child through that. When I was finally able to make him understand this, my husband reluctantly agreed to take me to a local back alley abortionist, an alcoholic quack who buried more than one of his mistakes. This was in 1954 when a dollar was worth perhaps 3 times what it is today. I had to hand this drunken butcher 1,000 of them before he even got through the door. After I swallowed my 2 aspirin anesthetic, I was told to climb up on what resembled a dirty kitchen table and hoist it on the chair. There followed a few obscene comments about my underpants and how I could take them off now. But I should have. Left them on before. The pain, eyeball popping pain, lots and lots of it. Far more, I'm sure, than was necessary. After the scraping into an already nearly full bucket procedure, so he offered me 20 of my $1,000 back for a quick blowjob. Another trip to the hospital, another 10-day stay, a little bout with peritonitis, half a dozen transfusions, all of which we could ill afford, and which put me back to square one when it came to owning my own home. And the old bro was as good as new. Almost, but not quite. Not in the sense that good is docile or tractable or pliant or amenable or submissive for 1 second willing to sit silently while anyone tries to bring back the back alley quack, the one they'll never have to patronize. Not because they don't have abortions, but because they do have approval. 27 years ago, I was physically and financially brutalized, not only by 2 treatment drugs, the first who raped, the second who pumped, but by a mild but blue-nosed and totally hypocritical society. A society that revered ignorance and made it the criterion for most of its laws. A society that made it a felony for any woman to own and control her own internal organs. All society which really hasn't changed very much for the better. and which is now on the verge of reversing the only good thing that happened to it in the 1970s. That's why, even at my age, I do what I do. Thank God for legal abortion. Miss Robertson, a writer and lecturer who lives in Peoria, Illinois, was so moved by Shelley Maxwell's story, the preceding chapter, that she wrote this account of her own personal experience. Taken together, the two essays make a dramatic contrast between the terrible days between the 1973 Supreme Court legalization of abortion and the brighter days thereafter. My husband and I are blessed with a bright, sweet, pretty 4-year-old daughter whom we wanted very much. Not even the 30 hours of labor or cesarean section delivery dampened our enthusiasm for the child we had planned and prepared for. She is a dear little dream come true. But several days after her arrival, I woke up sizzling like bacon on scales. Unceremoniously, I was moved from the bright maternity ward to a small gray isolation room. From my 105-degree fever topped out at 106.7, I broke out into excruciating raps and fell into a hell of unreality. Often I felt as though I was falling, endlessly helpless. I've not allowed the whole comparison to my husband, exhausted from the 30 hours beside me in labor and a grueling schedule of work, was dressed in masks and gloves when he came to visit. It became increasingly unreal for me. The room seemed to revolve slowly around day and night. The nursing staff seemed hostile as they had to speed up every time with intensity. Daylight hours passed in a rapid flow of frustration. Long, lonely nights stretched into black and empty eternities. The fifth day of no real contact with anybody and seemingly ceaseless pain and fear of falling into confusion. I saw grinning faces everywhere, on the walls and the bed covers, and I screamed until my husband rushed in and demanded my release from the hospital. Thus, my career as a mother began. My own mother, who had the flu during my ordeal, hadn't seen me for a week, when at the near shock at my death-like appearance when I shakily entered our home with the baby. Mom recovered quickly, though, and love out every possible way from the 2 weeks she could stay. For a year, I was afraid to go out much. Primitive late-night trips to 24 hours super my main contact with the outside world. I forced myself to return to the spiritual classes I joined shortly before my ordeal, and gradually I came to stop fearing what I had experienced. I finally regained the desire to move forward in my life and soon become acting, loving, and humorous. My physical health never really recovered. My attitude, I reverted to severe weakness and depression only occasionally. My husband and I were grateful for our healthy baby girl. We realized that it was a hospital, not her birth, but she was responsible for all the trauma. Nevertheless, we knew that childbirth and hospitals were not any part of our voluntary future plans. I was simply terrified to go back even for a simple sterilization, and we both felt that vasectomy was not necessary. My ovulation time occurred like clockwork, as evidenced by our immediate success in wanting to conceive, and our physical relationship was so happy and fulfilling that absolute continence during ovulation was no problem for us. We used condoms most of the rest of the time. This type of birth control had always worked for us to conceive and to not conceive. An older couple we knew who had used this method for 32 years, actually 2 grandchildren, had experienced no infections. So we'd assessed all the facts as we knew. We were completely responsible in our behavior. We went on with life. 3 years later, I woke one morning feeling very swollen and lethargic. I hadn't slept well because of frequent trips to the bathroom all night. All I wanted to do was sleep, but duty called. I struggled through the next few days, feeling a profound lassitude and interspersed with episodes of extreme irritability. I got into a vicious argument with a friend, something I had not experienced in many years. I cried. Hot flashes and chills began to play through my body, and I fell into uncontrollable periods of deep sadness or red-hot rage. Suddenly, resentment seized within me and my little daughter. I felt cosmically tired of being her nurse, nanny, companion, playmate, teacher, cook, favorite, groomer, and dresser. Tired of always walking at her pace. Tired of considering her comfort before my own. Tired of her constant interruptions as I tried to figure things out, as I tried to feel better. I thought of mother lions and how they often cuff their cubs. I felt like doing that all the time, although my level of goodwill was far below a line. When my period didn't start, I could not believe it. I had always been regular. But one morning thereafter, I woke up dizzy and slightly nauseous. I thought about pregnancy, but I was sure it was impossible because of our careful relationship. I waited out the vertigo for about 10 minutes and started down the stairs. Suddenly, I felt the skin on my breast contract as if it was hit by Arctic winds. It was a distressing sensation which I remember vividly from my first pregnancy. I sat down on the stairs in shock. It was all there, the swelling, the bloating. I could barely buckle my shoes, the emotional extreme, the crampy feelings as though a chunk of lead had been inserted into my wound. Painfully tender breasts now becoming extremely sore. No period, right down to the morning sickness. Dear God, no, I could not possibly be pregnant. Swallowing the bile of panic, I called Planned Parenthood rather than my regular physician with whom I had felt little affinity. They told me I'd have to wait another week in order to get accurate test reports. Planned Parenthood was direct, informative, and helpful, but I hung up the phone awash with humiliation. Now I was just going to have to sweat it out. The slang phrase knocked up drifted through my consciousness, something I hadn't heard about since high school. But that was exactly how I felt, like some dumb kid who might be knocked up and his life would be ruined. Somehow we all got through the week of waiting. I took the urine specimen in the clinic feeling ever more filled with shame. And the next day when my results were positive, the week of effort to control my wildly surging emotions all broke down. I wept all afternoon. I'm the woman who's watched a dear friend go into a sudden spinal hemorrhage and nearly died before my eyes. I remained strong and decisive throughout it to the point that the surgeon later said my presence of mind saved my friend's life. I'm a woman who's endured knee surgery and a year of painful invalidism with optimism. I'm a woman who's counseled a sister with cancer when all I wanted to do was cry at her possible death. I'm a woman who's sustained a mother in times of loss and grief. But I'm not a woman who can endure even the thought of childbirth in hospital again. The very idea of it reawakens all the hell and horror I experienced because I nearly lost my life in a hospital after childbirth and lost my will to live for nearly a year after that. I cannot, under any circumstances, ever again enter a hospital to have a child. I am too high risk for harm. Besides which, I simply do not want any more children. I have neither the strength nor the desire. I thought back. My husband left an upcoming business trip. My husband had an upcoming business trip, and we made love before he left. I said no protection was necessary since my period was due in a few days. Safe time. Always had been, but obviously it was not. Someone had changed the rules, and we were not being informed. There was no question for us about abortion. We went to the Planned Parenthood on advice of where to go. The nurse attempted to discuss alternatives with us. I emphatically told her that I thought adoption on abortion was wrong. I still feel abhorrent to the idea of deliberately bringing an unwanted pregnancy to term, delivering forth a helpless human being, and then giving it away for others to care for. To never again take any responsibility whatsoever for a baby deliberately brought to this world to be seemed utterly barbaric. By contrast, abortion is absolutely moral and responsible. To stop the pregnancy and prevent the birth of a child who can properly be cared for shows wisdom and understanding of the realities of life. The only life in an embryo is a woman's life within it. Until it can have a separate life, it is not a separate life. Infallible doctrines and dogmas simply wither away at the light of that fact. I had long recognized that anti-abortion ideas in the religious sector stem from fear of declining membership and therefore declining income, position, and power.
Where did you
Hello, my name is Katie, and I'm a student from Columbia, Missouri. I'm participating in the Women's Filibuster, which began on Monday, May 12th at 2 p.m. and is being held for 72 hours until Thursday, today, May 15th at 2 p.m. I'm here today because this session, politicians from Jeff City have spent countless hours advancing more than 30 bills that are hostile to women's health, including a dangerous bill that would triple the state's mandatory waiting period for a woman seeking safe, legal abortion. This bill is part of an intrusive agenda to undermine women's health and would create another barrier in the state in accessing a safe and legal abortion. Lawmakers should be trying to improve health outcomes in Missouri, not further restrict. Today, I'll be continuing where the previous citizen left off in the religious case for abortion from Protestant, Catholic, and Jewish perspectives. My husband and I both believe it is a measure of their desperation that they taunt murder at the surgical removal of protoplasm, which would never have tamed any individual life. but which just might have turned out to be an obedient tither in the future. We feel that life is truly sacred, but only if individuals are allowed the dignity of their own choices and personal beliefs. In this respect, the religious anti-abortion factions practice the ultimate hypocrisy. For if my life, as one example, is indeed sacred and worthy of respect, no one would ever think of forcing me through childbirth, which I dread worse than death. We left a donation at Planned Parenthood and looked forward to 2 days hence, when the debilitating symptoms and dreadful fears would be over. The one thought I had for the embryo was how dare anything grow in my body without my permission, wrecking my emotions, my health, my family, and my future. The unpredictability of nature. A double ovulation, perhaps, had dealt me a heavy blow. But it is my philosophy that spirit, the spirit of intelligence, invention, and determination, can overcome lower physical nature as an accidental pregnancy. And it was in that spirit that I finalized the arrangements for the abortion. We went shopping for groceries after everything was arranged, and there on the bulletin board was a Right to Life poster which said, "Pray to God for respect for life." It really hit me. What about respect for my life, or my family's? We were all going through acute misery because I was accidentally pregnant. Apparently, life to them is just an abstract concept that must be respected. But when it comes down to real people with real problems, they exhibit no respect at all. I realized then how deeply fortunate I was to be able to just call the clinic on reliable recommendation, make a prompt appointment, be quoted a reasonable price of $195, the thousands we'd spent on maternity costs flashed through my mind, and then go forth in the healthy light of day to a safe, clean place to restore my health and future. It made me sing. With a pang, I remembered the several friends and relatives prior to 1973 who endured furtive secrecy, no guarantee of safety, and incurred great expense to restore their lives to normal. I could not understand how this had ever been allowed in a free and humane society. I knew that if I had to search for help under threat of prison sentence and worry about safety and heavy expense on top of the already overwhelming symptoms, I would have lost my mind. My husband and little girl would have had a mental case on their hands instead of a wife and mother to care for them. Never do I want to hear that anti-abortionists are pro-family. This is ignorance and hypocrisy at its most malevolent. So standing before the anti-choice poster in the supermarket, I contemplated upon, "Pray to God for respect for life." And beneath it I penned, "And thank God for legal abortions." I kissed my husband. Everything was going to be okay. And indeed it was. Instead of the sick waves of dread I'd anticipated on the day of the abortion, I rose from a restful night of unaided sleep and went forth with a sense of relaxation and purpose. I had entrusted myself to God and felt buoyed by the Spirit. My husband said he wished he could have it for me, which made me feel even more loved and at peace. The clinic, which was full the entire time we were there, was the finest medical facility I'd ever seen. The counseling of the details of the procedure was sensitive and non-biased. Last-minute thoughts were conscientiously encouraged. The procedure was quick and safe. It was painful, but compared to unwanted childbirth, it was humane and a wondrous blessing. The day after the abortion, I felt happy and energetic. I felt deeply grateful. Here I was, a healthy and productive person, able to care for life and its responsibilities. After all, instead of an overwrought wreck, a burden on all. I felt more physically comfortable and emotionally released than I had ever felt in all my life. All this was over a year ago. Every day now, I thank God for legal abortion. And every night I go to sleep on a happy island of love and peace. The next is A Father's Story by Tom Braden. I've been wondering whether to tell you a personal story, which seems to me to have general implication. This is one of those sad family stories that normally you don't find fathers talking about in public, or even very much with close friends. But I picked up a newspaper the other day and read that a Senate committee had voted to abolish payments for abortion for the poor. even when the pregnancies are the result of rape. Now, this was not a question of cutting the budget. Abortion's costs for poor women who are raped do not amount to a large sum. Rather, it was a question of morality. Republican Senator Jesse Helms of North Carolina and the moral majority, which follows him around, are convinced that abortion is wrong, even when the woman who wants one wants it because she has been raped. So I don't think it will be very long before Jesse and his friends are going to come after the unpoor. That is to say, after you and me and our daughters. In this instance, I am not very comfortable about being unpoor. To object to what the Senate committee did, I object to what the Senate committee did. But I have the human instinct to object even more strenuously when I reason that, by the same standard with which the senators dealt with the poor, they will shortly deal with me. So let me tell you my story. A few years ago, one of my daughters attended an enormous 4th of July celebration at Washington Monument. It was a free show with fireworks and flags and entertainment, and, according to the newspaper account, the large crowd behaved well. But as my daughter strolled off along the monument grounds and entered a side street, a car rolled up next to the sidewalk. 3 men emerged from it, seized her roughly, and before she could do more than utter half a stifled cry, put her in the back seat, where 2 more men held her to the floor. She was tied, gagged, and taken to a house, the location of which she cannot now identify. She was kept in the house for the rest of the night, during which time she was repeatedly beaten and raped. The next morning, she was blindfolded, driven back to the monument grounds, and shoved out of the car. Eventually, sometime after midday, she made her way home. During the time she was gone, there was, of course, a great deal of worry and anxiety at the home, and I must confess, anger. Her arrival was followed by various interviews with policemen who tried to be helpful to a hysterical girl, but couldn't be, because the hysterical girl could only estimate the time she had been in the car, describe the inside of the house, and sob out some meaningless first names. All 5 assailants were black men, and the hysterical white girl's repeated description of them as being black was not definitive. That's really the end of the story. Except, of course, that within a very short time, my daughter knew that she was pregnant. Now I would like to ask Senator Helms what he would do if he had been the father of the girl. I know what I did, and I can promise the senator and the moral majority and all the shrill voices of the Right to Life movement that no matter what law they pass and how stringent the penalty, I will do it again. In defending his efforts to ban abortions for rape victims, Senator Helms says that almost no one gets pregnant from rape. This is a red herring whereby people come up 4 months later and say, oh, by the way, I was raped 4 months ago. But reliable surveys estimate that up to 15,000 pregnancies result from rape each year. And incest is often an additional factor. Mickey McConnell, who was director of the Phoenix organization and a prison minister before his death in 1982, wrote, research shows that most of the girls who become pregnant when they are below 15 years of age are impregnated by older men in their own families, fathers, stepfathers, uncles, cousins, etc., and that some of them don't even know how they've become pregnant. Next, I'm going to read a physician's testimony. Dr. George Ryan, president of the American College of Obstetricians and Gynecologists, made the following points in testimony before a Senate committee. What is the position of the American College of Obstetricians and Gynecologists on the Human Life Bill, which declares that human life shall be deemed to exist from contraception? Answer: we are opposed to the bill. for the simple reason that it would present great difficulty for obstetricians and gynecologists to provide health care to women who are pregnant. The bill assumes that every fertilized egg would go on to a normal pregnancy if it were left alone. That is not true. We see many tubal pregnancies and abnormalities in the development of the egg inside the womb. Some of these become cancerous. Do you believe life begins at conception? Answer. Biological life, yes. Human beings, no. For example, a woman who has had a husband and 2 children ends up with a pregnancy in her tubes. This can threaten her life. Some legislators are saying these few cells in her tubes have all the rights that her entire family has, and that we must jeopardize that woman's life. To me, this is nonsense. Question. But do you agree that life begins at conception? Answer. There is no question that the cell is living. But life is one thing when it should be considered human, when it should be considered human is not a scientific question. It is philosophical, moral, and theological. All these years we have said a human is entitled to all the rights of the Constitution at birth. This has worked pretty well so far. What economic effect would this bill have on these women? Answer. If abortions are made illegal, it means at least another 700,000 babies will be born next year. A substantial percentage will be born to the poor and the very young, about 2/3 of whom will collect welfare. Instead of a single cost of $125 for abortion, we will pay $1,000 to $1,500 for delivery, and at least $100,000 to support these welfare children until they reach maturity. This is a commitment of about $40 billion every year. Question. Some senators and congressmen say the cost doesn't matter. It is worth the price to save lives. Answer. The same people who want to save those babies are unwilling to get them food stamps. They don't care if the babies live in roach-infested houses. They don't care if they get adequate schooling. This is a strange contradiction, that the people who say they want to save lives have so little compassion for people after they're born. I'm more interested in the people who are already here. Next, I'm going to read Is Abortion Murder? By Graham Spurgeon. Bible scholar Graham Spurgeon, a Baptist, has written what many consider to be the most persuasive pro-abortion essay ever published in America. Question. What is your position on abortion? Answer. I believe that a woman should be free to choose whether or not to have an abortion. No one else should tell her what to do and what not to do. Question. Who wants to deny her this choice? Answer. There are many fanatics in our land who want to make all abortions illegal. Question. Are all anti-abortionists fanatics? Answer. No, and I respect those anti-abortionists who are willing to make concessions in a generous, humane spirit. For example, my esteemed brother in Christ, Billy Graham, approves of abortion in cases of rape, incest, or when the mother's life is at stake. When I talk about fanatics, I'm not talking about folks like Billy Graham. I'm talking about those cruel individuals who are against any and all abortions, period. Question. Is abortion murder? Answer. The fanatics say so, but they haven't looked closely at the Bible. Let's see what the Word of God says on this matter. In the Old Testament, a law was stated clearly for the children of Israel after they came out of Egypt. If, when men come to blows, they hurt a woman who is pregnant and she suffers a miscarriage, though she does not die of it, the man responsible must pay the compensation demanded of him by the woman's master. He shall hand it over after arbitration. But should she die, you shall give life for life, eye for eye, tooth for tooth, hand for hand, foot for foot. Exodus 21:22 through 24, Jerusalem Bible. In other words, if you cause the death of a fetus, you merely pay a fine. If you cause the death of a woman, you lose your own life. Thus, the Bible clearly shows that a fetus is not considered a person. If the fetus were considered to be a person, then the penalty for killing it would be the same as for killing a woman. Death. Abortion, then, is not murder. These verses in Exodus, by the way, are backed up by 4,000 years of Jewish law. Abortion has never been considered murder under Jewish law. A fetus is only a potential person. Question to further. Is abortion murder? Incidentally, the fine the Israelite man had to pay was not for the fetus, it was for hurting the woman. This is made clear in another translation of the same verses in the Revised Standard Version. The one who hurt her, the woman, shall be fined. There was no fine for hurting the fetus, because it was not considered a person. Question, but doesn't life begin at conception? Answer, no. Life begins before conception. The sperm is alive and the ovum is alive long before they get together at the moment of fertilization. As Dr. John A. Henderson says, life does not begin at conception. It is only changed and now has the potential for a different form. If terminating life is murder, then the anti-abortion fanatics should be consistent and say that terminating the life of an egg or sperm is murder. Believe it or not, there's a crackpot group in California that is making this very accusation. They say that males who masturbate should be punished because they are guilty of wasting human life in the form of semen. Question, if the embryo is a potential person, shouldn't it be treated the same way as a full-fledged person? Answer, an acorn is not an oak. A seed is not a rose. An embryo is not a human being. Nowhere in the Bible is the embryo or fetus given the status of a human being. Personhood does not begin at conception. Question, when does personhood begin? Answer, the Bible indicates that personhood begins when a baby emerges from the mother's womb. In the Bible and in modern life, birthdays are observed on the date of the baby's emergence from the womb. The precise moment of the beginning of personhood is when a baby takes its first breath. Question, why the first breath? Answer, because that's when God infuses the baby with a soul. Genesis 2:7 says, and the Lord God formed man out of the dust of the ground and breathed into his nostrils the breath of life, and man became a living soul. In other words, when an infant breathes its first breath, the soul enters its body and it achieves the status of a person. Question, doesn't God want every fetus to grow into a person? Answer, not according to the Bible. In Ecclesiastes 6:3, God compares the rich man who has led an empty, foolish life with a stillborn infant and says, I maintain that the stillborn child is in a better case than he. And Jesus said of Judas, it would have been better for that man if he had not been born. The world is better off without Judases and Hitlers and Charles Mansons, who quite often begin life unwanted, grow up abused and hated, and then take out their anger on society. How many psychopaths and destructive misfits will be born if anti-abortion fanatics force women to bear unwanted children? Question. The anti-abortionists say that when conception occurs, that means God wants a child to result. Answer. Whoever says that doesn't know biology. Consider these facts. 1. Between 1/2 and 2/3 of fertilized eggs in a woman fail to implant themselves in the uterus. They are washed away unnoticed. 2. In the United States each year, there are about 1 million spontaneous abortions, also called miscarriages. The abortions occur naturally. That is, the fetus is expelled from the womb without the assistance of doctors. In many cases, the woman is relieved of a horribly defective or diseased fetus. Scientists say this is nature's way of handling deformed fetuses. A religious person would say that God is merciful in bringing about the spontaneous abortion. Question, but the spontaneous abortion, miscarriage, is far different from induced abortion, isn't it? Answer: I don't think so. In many cases, abortion by a surgeon is simply a way of assisting nature, similar to the way we take various medicines to assist the natural processes of healing. Let's say that doctors discover that a pregnant woman is carrying a fetus that is horribly deformed. If abortion doesn't occur spontaneously, as in a miscarriage, then doctors are only assisting what normally should take place. Question: but isn't this going against the will of God and the natural course of things? Answer, in question form: is a surgeon doing wrong when he or she cuts out a malignant tumor? Question: why didn't God speak out explicitly on a question of abortion in the Bible? Answer: it wasn't an issue in biblical times. Neither was polio, but who would say that polio vaccine is against the will of God? In biblical times, abortion was not an issue because safe procedures were not known. Nowadays, abortion is safer than childbirth. Statistically, a woman is less likely to die from abortion than from childbirth. Question: why did God wait so long to give the world safe abortion? Answer: the world didn't need it as much in the past as it does now. I think He is showing mercy on us by giving us this safe surgical technique at a time when the world is almost choking to death from overpopulation. Human beings can't take care of children already on Earth. United Nations head authorities tell us that 1/3 of the world's children die of malnutrition before the age of 5. 1 out of 3. What kind of life is that? I think God is showing us He wants quality, not quantity. Question: the anti-abortionists would say that you are a baby killer. Answer: I happen to love children. I marvel at my own. They are little miracles. They are treasures. It is because I treasure babies that I am for abortion. I want to see babies that are wanted, loved, and adored, not babies that are hated and abused and forced into the world because of the misguided zeal of fanatics. Question: some anti-abortionists say that abortions in America constitute a Hitler-style Holocaust. Answer: this is ironic because Hitler, and Stalin as well, outlawed abortion. Totalitarian regimes want to control every aspect of a person's life, including a woman's reproductive system. In America, by contrast, when our founding fathers wrote the Constitution, early abortions were legal. Allowing women to control their bodies is the American way. Treating women like cattle is the totalitarian way of dictators and ayatollahs. Question: won't the American family be weakened by legalized abortion? Answer: no. What would weaken the family is for government to strip parents their right to decide their family size for themselves. Question: wouldn't widespread abortion make people callous to human life? Answer: no. To the contrary, it would be society's way of saying life is important. Children are important, and they shouldn't be brought into the world unless they can be loved and provided for. Child abuse is a sin and a crime. See Jesus' remarks in Matthew 18:6. But the anti-abortionists say that unwanted children can be put up for adoption. Answer: this is a cruel hoax. All this talk about adoption. There are currently 120,000 children in this country and uncounted millions elsewhere in the world who are unadoptable. Nobody wants them. Blue-eyed, blonde, white-skinned children are quickly adopted. But if a child is black, or physically handicapped, or mentally retarded, he or she is not likely to find a permanent home. It's a shame, but it's true. Incidentally, there are many black couples who would love to adopt black babies, but can't afford to. Question: can you give an example of a case in which abortion is the desired alternative? Answer: a mentally retarded 12-year-old girl was raped by her father and she became pregnant. Doctors' tests indicated that the fetus was physically deformed with a strong probability of mental retardation. The girl's mother, who was living in terrible poverty, wanted the girl to have an abortion, and her pastor concurred. I think God favored this abortion. There are many other cases, of course, which could also be cited. Question: do you think the babies that do come into the world with handicaps should be killed? Answer: of course not. Once a baby is born, it is to be loved and cherished and helped as much as possible. Here is an interesting comment made by a woman who wrote to columnist Ann Landers. I am the mother of a child with Down syndrome. I believe that a special child can enrich one's life. My husband and I have devoted a major part of our waking hours these past 12 years to making sure our son has a full and productive life. Our older children have also made this commitment to their brother. Given the chance, we would choose to have the beloved child again, just as he is. We would also choose to bring another one like him into the world. Choose not to bring another one like him into the world. Why? It is not that we lack compassion. It is simply a matter of energy. She goes on to say that she and her husband are strongly in favor of a woman's freedom to choose whether or not to have an abortion. Question: the anti-abortionists talk about the pain that the fetus feels during abortion. Is there really pain involved? Answer: yes. Any abrupt changes in tissue structure results in distress. Yes, the fetus twitches. But you could carry this pseudo-scientific logic to an extreme. Scientists have proven that plants are as sensitive as animals. When plucked by their roots, they scream with electrophysiological pain. Should we therefore stop harvesting vegetables because of this pain? I am not moved by the pain of an embryo, which is a smidgen of tissue. At 4 weeks, an embryo is no bigger than a kernel of corn. Don't let blown-up photographs mislead you. I am moved, however, by the abuse of a child who is battered and slashed by parents who never wanted him. Question: are you saying that anti-abortionists are indifferent to the pain of child abuse? Answer: though many anti-abortionists are fine, sensitive human beings, the fanatics among them seem to have a concern that begins with conception and ends with birth. Columnist Carl T. Rowan says that the fanatics want to force poor women to have babies, curse them when their children go on welfare, deny the children even a minimum level of decency, then wait for them to get pregnant at age 12 or 13 when they can tell them, no abortions, you must have babies. Question: do you admire the anti-abortionists for being motivated by reverence for life? Answer: that's not their main motivation. Their main motivation is revenge. They want to see pregnant teenagers suffer the consequences of their sin. I have seen the evil gleam of vengeance in the anti-abortionists' eyes as they say, she had her fun to pay the price. When the mob wanted to stone a woman who had committed adultery, Jesus said, he that is without sin among you, let him first cast the stone at her. John 8:7. I'm afraid that if Jesus were to repeat those words today, these self-righteous hypocrites would pick up stones and smash the poor girls who have been guilty of making a mistake. Stoning is not far from what these fanatics are in fact trying to do today. They are not so much pro-life as they are pro-vengeance. Their stones are these cruel words: you must have that baby. To the woman who says, I have 7 children already, the fanatics reply, you must have that baby. To the woman who says, I was raped, the fanatics reply, you must have that baby. To the woman who says, my doctor says I will die if I have this baby, the fanatics reply, you must have that baby. You must have that baby. Words of stone, crueler than stones hurled at sinners in Jesus' day by self-righteous Pharisees. Question: isn't it a good thing for teenage girls to be made afraid of getting pregnant? Doesn't this discourage premarital sex? Answer: I share the anti-abortionist concern about teenage sex. I think it's wrong. We should try to discourage teenage sex and teach young people that sex is a part of marriage. But studies show that fear of pregnancy does not deter sexually active teens from having sex. They have the attitude, it won't happen to me. Question: Well, shouldn't pregnant teenagers be made to suffer the consequences of their wrongdoing? Answer. If the girl wants to go ahead and have the baby, fine. But she shouldn't be forced to have it. Why? Because the one who will suffer the most is not the mother, but the child. Unwanted, unloved children are frequently abused, and they often grow up to become delinquents and criminals. Then society is made to suffer as well. The punishment of the mother is enormously out of proportion to the crime. How do you know that unwanted children often become criminals?
Hello again. I'm going to read from some material we have here. Researchers have also examined the impact of mandatory counseling and waiting period laws on the cost of an abortion, a woman's emotional and physical experience in obtaining an abortion, providers' experiences regarding the laws, infant and child health outcomes, the financial costs for providers, and female suicide rates. Two studies examined the qualitative experience of abortion providers and their patients. Three studies evaluated the impact of mandatory counseling and waiting period laws on infant health outcomes, and one study investigated the relationship between such laws and suicide rates. Qualitative experiences of patients and providers. Lupfer and Silver interviewed more than 300 women at 3 clinics in Tennessee about their experiences obtaining abortions following the implementation of a mandatory counseling and waiting period law in 1979. The law required that a woman wait at least 2 days before being examined in person by a physician and being informed about the benefits and risks of pregnancy and abortion before having her abortion. Counselors or research staff asked women questions about their perceptions of the benefits and costs of the law, either after completing the mandatory waiting period or both before and after the period. Interviews took place from October 1979 through January 1980, starting just 1 month after the law was implemented. The researchers found that the cost of an abortion increased for the majority of women. 62% reported that the required second visit increased the cost because of lost wages and additional transportation and child care expenses. The study found that the second visit elevated cost by 48% for low-income women and 14% for women with high incomes. Fees were often scaled according to the ability to pay, and the amount of increase was associated with a woman's distance from the clinic and the number of hours she was employed for. 77% of women were unable to name a benefit of the waiting period, and some women reported negative mental, physical, and social consequences. 29% experienced mental anguish, 24% incurred extra transportation costs, 19% experienced additional nausea they attributed to the delay, 15% missed time at work, and another 15% had to make excuses to explain their absence. 8% said that others missed time at work to transport them, 5% had to arrange for a babysitter, and 1% may have entered into the 4th month of pregnancy because of the imposed waiting period. The authors found that the cost of compliance did not differ by race, age, income level, or student status of the women. Although Lupfer and Silver tried to limit interviewer bias during the patient interviews, more than 200 of the sessions were conducted by counselors employed at the clinics. This may have biased responses since the counselors had relationships with the patients, who may have answered in ways they believed the counselors would approve of. However, as an early study that looked at the impact of mandatory counseling and waiting period law immediately after implementation, this study provided excellent first-hand data on patient experience. But because the data were collected nearly 3 decades ago, a new survey would be valuable since these kinds of laws are now widespread, and women and providers may have adjusted to the laws in ways that might mitigate some of their impact on access to abortion service. Examining the other side of service provision, Althius and Henshaw interviewed clinic administrators in 2 clinics in Ohio and Pennsylvania from August to December 1992 to assess how mandatory counseling and waiting period laws affected them and their practice. At the time, Ohio law dictated information about the methods and risks of the abortion procedure, the probable gestation age of the woman's pregnancy, medical risks associated with the continued pregnancy, and other information had to be provided in person, by telephone or mail at least 24 hours prior to an abortion. Pennsylvania's mandatory counseling and waiting period law required that a physician verbally inform a woman of the nature of the abortion procedure, the risks involved in abortion and childbirth, and the probable gestation age of pregnancy at least 24 hours before the procedure. The woman was also offered information about the availability of state-produced written materials describing the fetus and medical assistance for continuing the pregnancy, the father's liability for child support, and agencies that could provide alternatives to abortion. The law was interpreted to mean that this information must be given in person, hence requiring 2 trips to the clinic for an abortion. At the time of data collection, the Pennsylvania law had been in effect for only 4 months. Although neither clinic had yet conducted a formal analysis of the effect of the law on their service provision or fiscal outcomes, providers did note a sudden scheduling nightmare for patients, a decrease in the number of appointments made, and an increase in required staff and staff time. Furthermore, the authors were told that costs associated with staffing, printing extra consent forms, purchasing the state-prepared brochures, and mailing the brochures to patients had become a financial burden for some clinics in these states. For example, the cost at one clinic in Ohio rose by 10%. The authors noted that the experiences of providers may change over time as they learn to adjust to the requirements of mandatory counseling and waiting period laws. The study was limited by the small number of providers surveyed and an inability to follow providers over time to see if they adjusted to the laws. Nevertheless, their data provide valuable direct information on the immediate burden that such laws place on abortion providers. Infant and child health outcomes. 2 papers by Bittler and Zavandi used annual state-level data on indicators of child maltreatment. In the first paper, the authors analyzed reports of child abuse and neglect between 1976 and 1996 to assess the possible correlation between mandatory counseling and waiting period laws and these outcomes. In a later paper, they expanded the outcomes to include the receipt of children's social services and the rate of child mortality attributed to possible abuse and murder. They also assessed the effect of abortion legalization in the early 1970s on these outcomes. The research found that both enforced and enjoined mandatory counseling and waiting period laws were associated with a 5 to 23% decline in child abuse reports in the year the law was either enforced or enjoined. Their results varied by outcome and by when the law was assigned to the outcome. For instance, coefficients changed from positive to negative when the laws were assigned to the year of conception rather than the year of receipt of social services or death. In the second paper, the results were also inconsistent as association varied with different measures of abuse. For example, the authors determined that enjoined mandatory counseling and waiting period laws were strongly associated with an increased number of abuse reports, but with a decreased number of substantiated victims. The latter were analyzed only for the period 1990 to 1996. When they analyzed relative changes in the outcomes using logarithms, the estimated effects were substantial. 32 to 63% declines in the number of substantiated victims. Enjoined laws were also associated with a 45% increase in the rate of murder of a child by a relative or unknown person, but were unrelated to murder by a parent. Bittler and Zavandi's results for mandatory counseling and waiting period laws strain credulity. First, the estimates fluctuate dramatically depending on the outcome in years. This is not surprising given the laws were not consistently enforced until the Supreme Court decided Planned Parenthood in southeastern Pennsylvania v. Casey in 1982, and also because, according to the author's own assessment, few individuals in their sample were exposed to the laws. For instance, they report that only 0.1% of the sample was subject to an enforced mandatory counseling and waiting period law between 1979 and 1996, and only 0.3% was exposed between 1990 and 1996. The proportion of their sample exposed to an enjoined law was never greater than 1%. Furthermore, effects as large as 30 to 60% probably indicate omitted variable bias, as does their finding that enjoined laws often had larger effects than laws that were enforced. Finally, the relationship between mandatory counseling and waiting period laws and child abuse is reportedly attributed to an increase in unintended childbearing associated with these laws. There is no evidence that such laws have a statistically significant effect on birth rates, even in Mississippi, where the results appear to be most robust. Without this connection, there is no compelling explanation for how the laws could enforce child abuse. Sim tested the hypothesis that state-level restrictions on abortion were linked to increases in children's rates of fatal injuries. She analyzed 3 restrictive policies: mandatory counseling and waiting period statutes, Medicaid financing with abortion, and parental involvement laws. Her reasoning, similar to that of Bitler and Zamandi, was that abortion restrictions might disproportionately increase births of unwanted children as well as births to young, single, and low-income women, which might in turn lead to adverse child outcomes. The author analyzed state-level data on fatal injuries among children aged 0 to 4 for all 50 states for the period 1981 to 2002. She chose this age range because she argued that past analyses have suggested that children in this group are the most vulnerable to fatal injuries associated with abuse or neglect. 3 causes of injury-related deaths were considered: homicide, unintentional causes of any type, and unintentional causes other than the motor vehicle crashes in which the child was a passenger. A count data model with state and year effects was used for estimation. The results for each cause were presented for white and black children. The author found that the mandatory counseling and waiting period laws were associated with a 24% increase, though not statistically significant, in homicide deaths and a statistically significant 9% increase in unintentional fatal injuries among white children. Among black children, homicides were 30% higher in states with enforced laws. All other results were not statistically significant. Sin also conducted falsification tests in which she regressed fatal injury rates among adults aged 25 to 54 on indicators of abortion restrictions. Any association among adults would be considered spurious and would call into question similar associations with fatal child injury rates. Indeed, Sin found that such laws were correlated with high rates of homicide among black and white adults, and with a higher rate of unintentional fatal injuries among black adults. Sin's study suffers from the same deficiencies as do Bitler and Rodney studies. First, there is no evidence that mandatory counseling and waiting period laws cause a meaningful increase in unwanted child bearing, which is a seemingly necessary condition for an association with the measure of child abuse. Second, Sin makes no distinction between such laws that require 2 in-person visits in both cases. Third, only 6% of her sample was exposed to these laws, and substantially fewer were exposed to the strictest formula law. Finally, since mandatory counseling and waiting period laws were correlated with fatal injuries among adults, they failed Sin's falsification tests. This is a strong indication that her model did not control adequately for other determinants of fatal injury rates. Suicide rates. One study in our review measured the effects of mandatory counseling and waiting period laws on female suicide rates. Click examined suicide rates among women aged 25 to 64 in all states using a pooled time series analysis of data from 1981 to 1998. In a multivariate model, he included the proportion of the year in which a Medicaid funding restriction was in place, as well as controls for other potential confounders, such as women's labor force participation, the unemployment rate, average state income, portion of the state's population living in rural areas, education levels, and religious identification. In some cases, he included male suicide rates to control for unobservable variables that might affect female rates. In the most basic regression, it was found that mandatory counseling and waiting periods were associated with 10% reductions in female suicide rates. These estimates were robust to the inclusion of the state-specific linear trends, as well as to the male suicide rate. He noted that laws that restrict abortion access were more likely to be implemented in more politically conservative states, and thus may be correlated with unmeasured changes that cause suicide rates to fall. Purged his estimates of this potential omitted variable bias. He used an instrumental variables approach and found that such laws were associated with a 30% decrease in suicide rates. The author concluded that the waiting periods induce a more reasoned approach to the abortion decision. Despite the apparent thoroughness of the regression analysis, Click's findings lack transparency and plausibility. First, if mandatory waiting periods are indeed associated with a 30% decline in suicide rates, then such large discontinuities should be apparent in the time series of suicide rates in the states that have enforced these laws. Click provided no such figures or even simple differences of suicide rates in states with counseling and waiting period laws and neighboring states without them. Second, it is unclear why Click included suicide rates from 1981, when the first laws were not enforced until 1992. Nor did he analyze the association between suicide rates and mandatory counseling and waiting period laws in this earlier period, which accounts for over 60% of the sample. Such an analysis could have served as a check for spurious associations. Third, Click found that mandatory counseling and waiting period laws were protective against suicide, but Medicaid but that Medicaid financing restrictions increase suicide rates. Yet he did not provide a convincing explanation for these seemingly contradictory results, given that both types of restrictions decrease women's access to abortion. Quick speculated the Medicaid restriction reduces the number of abortions, but the resulting unwanted births among relatively poor women lead to depression and suicide. In contrast, he suggested that mandatory counseling and waiting period laws may reduce abortions and increase unwanted births, but the non-poor women may respond to unintended childbearing with greater acceptance of the child, and so suffer less depression and be less likely than poor women to take their own lives. Click further argued that if these laws have no effect on abortion rates, they may still reduce suicide rates by helping women who are comfortable with their decision to terminate the pregnancy, thus reducing post-abortion regret and depression. He provided little support for these various speculations. Finally, Click included women aged 25 to 64 and excluded those aged 18 to 24. The latter age group has the highest abortion rate, while many of the older women that he included were beyond their reproductive years. The test would be effective in joint mandatory counseling and waiting period laws would have helped to determine whether unmeasured confounding variables were influencing the results. Early qualitative assessments of experiences with mandatory counseling and waiting period laws found that abortion patients and providers were burdened in multiple ways by the legislation. Women who had obtained an abortion described negative physical and mental health consequences such as physical discomfort and mental distress. Women also reported increased burdens from having to visit clinics multiple times and having to travel out of state to a provider who is not affected by such laws. Interviews with providers suggested that many struggle to adjust to the laws immediately after implementation. These early findings make intuitive sense, as any change in this type of regulation will have some effect on providers and patients, particularly as the logistics of meeting the new requirements are being worked out. But it's important to note that these studies were conducted in a limited geographic area and include a relatively small number of women and providers. Despite the limited generalizability of qualitative studies, they are valuable because they are the only ones to evaluate mandatory counseling and waiting period laws using such methods. The remaining research on mandatory counseling and waiting period laws fell into two groups. Case studies that focused almost exclusively on Mississippi and state year analyses that examined changes in reproductive outcomes, infant or child outcomes, or suicide across all or almost all states over time. The results from Mississippi were the most convincing. Overall, the state's mandatory counseling and waiting period statute, with this requirement that all counseling be done in person 24 hours prior to an induced termination, was associated with a decline in the abortion rate, a rise in abortions obtained out of an increase in the proportion of second trimester abortions. These findings were consistent across three studies, each with a distinct research design. The other convincing aspect of the Mississippi studies was the nature of the data. For each study, researchers collected information about abortions obtained by Mississippi residents in that state, as well as Tennessee and Alabama. This proved critical, as the number of women who left Mississippi for an abortion in a neighboring state was substantial. Finally, the outcomes analyzed were affected immediately by the law, and the statistical approaches were simple and transparent, which made the results easy to evaluate. Because Mississippi differs so much from other states demographically, economically, and politically, it is unclear whether the effect of equally restrictive law in other states would be greater or less than Mississippi. Unfortunately, few other states have collected the necessary data to follow analysis of the impact of mandatory counseling and waiting period laws. The broader analyses that included data from all available states found that counseling and waiting period laws had no impact on abortion rates or birth rates. Most laws are less demanding than that of Mississippi, and it's probably safe to conclude that if they affect reproductive outcomes, the effect is not large. However, the possibility of unmeasured confounding variables and other limitations of the studies preclude ruling out small effects. The corollary finding is that mandatory counseling also has little effect on women's abortion decisions. Some states require that specific information be provided to the woman before the waiting period. If the delay has no effect, neither does the mandated counseling. Finally, the studies of impact on child abuse and mortality and on women's suicide rates are unconvincing because of anomalous findings and the lack of evidence that the laws increased unintended childbearing enough to account for the results. We conclude that the mandatory counseling and waiting period laws that require an additional in-person visit before the procedure likely increase both the personal and the financial costs of obtaining an abortion, thereby preventing some women from accessing abortion services. Neighboring states have similar laws so that access to an abortion provider who does not require the strict form of waiting period requires extensive travel. And such laws are likely to lower abortion rates, delay women who are seeking abortions, and result in a higher proportion of second trimester abortions. Laws that allow mandatory counseling to be delivered over the internet or by mail or telephone impose lower costs on both patients and providers, and neither the waiting period requirement nor the counseling appears to have a large impact on reproductive outcomes. However, by definition, such statutes do cause some delay, and one study that addresses this issue found a 41% increase in the rate of second trimester abortions. While this might not be an accurate measurement of the magnitude of the effect, it is likely that some abortions are delayed to the second trimester. Oh, I got material here. Just trying to find what to read next. Okay, we're going to move on to an article called Abortion and Informed Consent, How Biased Counseling Laws Mandate Violations of Medical Ethics. Imagine a doctor who has a moral objection to the use of birth control pills. A patient comes to him seeking a prescription for the pill, but he tries to discourage her. He exaggerates the risk to her health, and he tells her that she may experience various side effects, even when there is no scientific evidence of such effects. During their conversation, he tells her graphic details about another form of tubal ligation surgery, and shows her photographs of such a surgery being performed, even though the patient expressed no interest in tubal ligation, and in fact, she did not want to hear about that surgery once the doctor brought it up. Finally, he tells her that birth control is morally wrong. At the end of this conversation, the patient tells the doctor that she has considered her options and the information the doctor gave her and is ready to proceed with the pill. However, the doctor sends the patient home to think it over, telling her she must wait at least one day. Because of the patient's work and childcare obligations, she is not able to return the doctor's prescription until the following week. The doctor's actions would strike many people as morally wrong. He used deception, frightening, and medically irrelevant information, and the practical obstacle of delay to try to prevent this patient from obtaining medication, all as ways of imposing his moral view on the patient. In fact, there is an ethical doctrine that regulates the practice of medicine that can be used to evaluate the moral character of the doctor's actions, that of informed consent. At its heart, the doctrine requires that healthcare professionals provide their patients with sufficient information to allow them to make an intelligent decision as to whether to undergo a medical intervention, and that that the patient's decision determines whether the patient undergoes the intervention. If we slightly change the facts of the story about the discouraging doctor, it becomes a story that happens every day. Abortion patients face attempts to discourage them from terminating their pregnancies, like those the imaginary doctor used, as well as others, and state laws mandate these attempts. While the law of every state requires healthcare professionals to secure the informed consent of the patient for any medical intervention, over half of the states place additional requirements on legally effective informed consent for abortion. These laws sometimes include features that have ethical problems, such as giving patients deceptive information. Such laws are part of anti-abortion activists' strategy to chip away the legal availability of abortion in the U.S. by heavily regulating the practice of providing abortions. These laws are examples of abortion exceptionalism, in which abortion is singled out for more restrictive government regulation as compared to other similar procedures. Various justifications are offered for abortion-specific regulations, but at heart they are driven by moral opposition to abortion and legislators' desire to come as close as possible to banning it without enacting a law that would be struck down as unconstitutional. Unique informed consent requirements for abortion are depicted by their supporters as necessary for fully informed and voluntary consent to abortion. They are purported to protect health by regulating the practice of medicine. but their worst features are detrimental to both the goals of the doctrine of informed consent and to women's health. I refer to these laws as counseling laws because they are not intended to ensure that patients give their informed consent to abortion, but rather they are intended to make a woman less likely to terminate their pregnancy. I employ a broad definition of bias counseling laws for my purposes. Any law that is intended to discourage women from deciding to obtain abortions is a bias counseling law. However, not all abortion-specific consent laws are equally ethically problematic. Thus, my argument will focus on certain features of bias counseling laws. This article contributes to the literature by examining in detail the most problematic feature of bias counseling laws, collecting and explaining some of the most influential ethical accounts of informed consent, and demonstrating the deep ethical problems with bias counseling laws. Legal scholars have previously argued that bias counseling laws are unconstitutional because they impose an undue burden on the right to terminate a pregnancy, violate the First Amendment, and they constitute sex discrimination. This article shows that in addition to their shortcomings when judged by the standards of the Constitution, bias counseling laws have serious problems when judged by the standards of medical ethics. The article provides an innovative interdisciplinary analysis of statutory provisions in an area in which legislatures have been highly active in recent years and will likely continue to be. Part 1 sketches the legal doctrine of informed consent, which constitutes useful background for understanding the related ethical doctrine and illustrates the baseline of general informed consent requirements that abortion-specific laws go beyond. The ways in which bias counseling laws exceed general informed consent requirements are an example of abortion exceptionalism, the strategy of regulating abortion more stringently than similar medical procedures in order to decrease patients' access to the procedure. Part 1 also draws attention to the Supreme Court decisions discussing informed consent to abortion laws that contain the troubling beliefs held by supporters of bias counseling laws. Part 2 describes several bias counseling laws, pointing out specific features that have medical ethical significance. Part 3 surveys several well-developed influential accounts of informed consent from the field of medical ethics, as well as the positions of 2 medical professional associations. I apply each of them to the features of bias counseling laws that are discussed in Part 1 and argue that none of them provides a justification for the problematic features of bias counseling laws. In fact, those features of bias counseling laws are deeply flawed according to all of the ethics authorities this article examines. Part 1, the legal context. A, the legal doctrine of informed consent. The tort doctrine of informed consent in the United States was developed in the common law in the early 20th century, though it has been codified in many states. The doctrine has shifted in its legal consequences. Initially, a doctor's failure to obtain informed consent created a cause of action surrounding sounding and battery, protecting the patient's bodily integrity, but the cause of action later generally came to be thought of as a sounding and negligence. The key element of informed consent is that the doctor must disclose material risks to the patient. About half the states define material risks as those in which a reasonable person would likely find significant in deciding whether or not to forego the proposed therapy, while the other half defines the term by reference to the professional practice and what a reasonable physician would disclose. Under the doctrine, the decision belongs to the patient. The patients have the right to refuse medical interventions. Thus, informed consent is the legal recognition of the medical patient's protectable interest in autonomous decision-making. The fundamental value undergirding the doctrine is generally considered to be the patient's autonomy. There are 4 widely recognized exceptions to the requirement that a physician obtain informed consent to a medical intervention: emergencies, patient incompetence, patient waiver, and therapeutic privilege, a doctrine that allows doctors to refrain from making a disclosure where it will seriously harm the patient. Other sources of law buttress this tort doctrine requiring informed consent for medical treatment. Although the two are distinct, there is quite a bit of convergence between the principle underlying tort law doctrine of informed consent and the constitutional right of privacy. Both doctrines are undergirded by the value of individual autonomy. In addition, the right not to be subjected to medical treatment without one's informed consent is a human right that is guaranteed to individuals in the United States by the International Covenant on Civil and Political Rights. The ICCPR It requires state parties to ensure that patients give full and informed consent to medical procedures. The legal doctrine of informed consent and the ethical doctrine of informed consent are analytically distinct, although they have been intertwined in their historical development. It's conceptually possible for the legal doctrine to place an obligation on doctors that the ethical doctrine is silent upon or even prohibits. This article argues that biased counseling laws violate the ethical doctrine. I will not analyze the legal doctrine in any detail. B. Abortion exceptionalism. Since every state has generally applicable informed consent laws, statutes that require more involved consent protocols are an example of abortion exceptionalism. This is the anti-abortion legislature's strategy to decrease the number of abortions by placing numerous regulations on abortion where similar procedures are unregulated, making abortions more difficult and more expensive to provide. Abortion providers often face more stringent regulations than other healthcare providers, such as physicians' offices or outpatient surgery facilities that have similar risk profiles. Abortion providers are often required to obtain licenses, be subject to inspections, maintain certain written policies, and meet physical plant requirements, even when other healthcare providers are not. While most regulation of the medical profession is enforced only by professional sanctions such as disciplinary action by a licensing body, abortion regulations are often backed by the threat of criminal penalties, including prison sentences. Provisions like the federal Hyde Amendment and similar state laws prohibit public funds from being used to pay for abortion on the basis that taxpayers who oppose abortion should have to pay for it. However, there are no similar provisions prohibiting taxpayer money from funding other activities that are morally offensive to a large number of Americans, such as the production of highly destructive military weaponry. The popularity of laws that create unique requirements for legal, effective, informed consent to abortion stands in contrast to the rarity of informed consent laws specific to other procedures. Some states have informed consent statutes specific to sterilization. Some states have laws specific to breast cancer treatment, and some showed special concern for psychological treatment, like electroconvulsive therapy and psychotherapeutic drugs. Other statutes provide specific disclosure requirements for telemedicine, which is the provision of medicine remotely through the use of telecommunications, or for umbilical cord blood banking. Interestingly, unique application to women or reproduction is a feature of most of these areas of special regulation and consent. Sterilization is one area where the state shows its desire to regulate reproduction and specifically to protect childbearing capacity, just as it does in the abortion context. Two others involve medical circumstances faced only or primarily by women, breast cancer and umbilical cord blood banking. This gender distinction fits with the notion that women need special protection in their medical decision-making, which is an important aspect of anti-abortion policy-making, as I discuss in the next section. C. The constitutional right to abortion and views of women's decision-making. The United States Constitution protects the right to terminate a pregnancy. The constitutionality of laws that impact the right to abortion is judged by the undue burden standard articulated in Planned Parenthood of Southeastern Pennsylvania v. Casey. The Supreme Court's abortion jurisprudence in Casey since touches on informed consent principles and women's autonomy. Apparent in these decisions is a troubling strain of paternalism and distrust in women's decision-making ability. The court's use of these ideas in decisions regarding which forms of abortion regulation are constitutionally permissible help illustrate how such regulation in the form of biased counseling laws conflicts with the doctrine of informed consent. Casey departed from prior Supreme Court decisions by enhancing the government's interest in promoting life or potential life of the unborn. The plurality reasoned that while the government may constitutionally act to further an interest in potential life by persuading women to choose childbirth over abortion, the means it uses must be calculated to inform the woman's free choice, not hinder it. One of the many restrictions in the Pennsylvania abortion law that was upheld in Casey was a biased counseling provision. The statute requires that 24 hours to an abortion, a woman must be orally informed of the gestational age of the embryo or fetus, and the nature and risks associated with the procedure and alternatives, and must be offered state-produced materials that describe the unborn child and list agencies which offer alternatives to abortion, among other disclosures. The Casey plurality had no trouble upholding the misdisclosure, approving the requirement to give truthful, non-misleading information about the procedure and its risks. With the following language, which appears in the portion of the plurality opinion, upholding disclosures about gestational age and fetal development, reveals the plurality's views of women's capacity to decide whether to terminate their pregnancies. It cannot be doubted that most women considering abortion would deem the impact on the fetus relevant, if not dispositive to the decision. In attempting to ensure that the woman apprehend the full consequences of her decisions, the state furthers the legitimate purpose of reducing the risk that a woman may elect an abortion, only to discover later, with devastating psychological consequences, that her decision was not fully informed. A plurality statement contains wholly unsupported empirical claims about what women think. The plurality writes as if the law requires disclosure of the consequences of abortion to the embryo or fetus, when it is common knowledge that abortion results in its destruction. The disclosure at issue is not about what the consequences are, but what the embryo or fetus looks like, information which is clearly not relevant to the patient's decisions. Finally, and most importantly, the plurality betrays the skepticism of women's decision-making ability and autonomy by assuming that it is inappropriate for the state, is appropriate for the state to protect women from their putative inability to think through their own decisions and then face the consequences of those decisions. Turning to the Pennsylvania law's waiting period, the Casey plurality said, the idea that important decisions will be more informed and deliberate if they follow some period of reflection does not strike us as unreasonable, particularly where the statute directs that important information become part of the background of the decision. We should ask, what is the problem the state is addressing here? Why do policymakers believe that women are unable to take sufficient time to make the decision on their own and need to be forced to sleep on it?
May I inquire my fellow Missourians?
Yes, ma'am.
Thank you. Hi, my name is Vivian Wheeler. I'm 26. I'm from Springfield, Missouri, and I'm participating in the Women's Filibuster, which began on Monday, May 12th at 2 p.m. and it's being held for 72 hours until Thursday, May 15th at 2 p.m. I'm here today because I believe that reproductive health care matters. I think it creates healthy citizens in a healthy state. And I think these laws are cumbersome, egregious, unnecessary, and insulting. This session, politicians in Jefferson City have spent countless hours advancing more than 30 bills that are hostile to women's health, including a dangerous bill that would triple the state's mandatory waiting period for a woman seeking a safe, legal abortion. This bill is part of an intrusive agenda to undermine women's health and would create another barrier in the state in accessing a safe and legal abortion. Lawmakers should be trying to improve health outcomes in Missouri, not further restrict. And turning to Pennsylvania's law waiting period, the Casey plurality said the idea that important decisions would be more informed and deliberate if they follow some period of reflection does not strike us as unreasonable, particularly where the statute directs the important information to become part of the background of the decision. We should ask, what is the problem the state is addressing here? Why do the policymakers believe that women are unable to take sufficient time to make a decision on their own and need to be forced to sleep on it? This is one part of the bill I find particularly insulting. What is more, informed consent is a doctrine designed to help patients make decisions when they need medical information to decide among treatment options, but the decision of whether to bear a child goes far beyond that. Yet Casey treats the state's disapproval of abortion as if it were relevant as the medical risks. Even if the state has a legitimate interest in discouraging abortion, that does not entail that it is appropriate to use the informed consent process to express that interest or intrude upon the relationship between doctor and patient. In its most recent abortion decision, Gonzalez v. Carhart, the Supreme Court upheld the so-called Partial Birth Abortion Ban Act of 2003 against constitutional challenge. The federal statute places a criminal prohibition on some methods of abortion. The positions challenging the act argued, inter alia, that it placed an unconstitutional undue burden on the right to abortion by imposing a substantial obstacle in the path of women seeking abortions. Carhart cited Casey for the proposition that the state does not impose an undue burden on the abortion right with regulations which do no more than create a structural mechanism by which the state may express profound respect for the life of the unborn. If they are not a substantial obstacle to the women's right to the women's exercise of the right to choose. The court found that the statute's prohibition on abortion methods that involve the partial removal of a fetus from the uterus before fetal demise was justified by the government's interest in showing its profound respect for the life within the woman. The court accepted congressional findings that procedures that are similar to infanticide should be prohibited in order to maintain a bright line between abortion and infanticide. In addition to the government's interest in protecting the dignity of human life by prescribing certain methods of terminating pregnancies, the court found that the government's interest in protecting women from the consequences of their own actions was a purpose that helped keep the statute from imposing a substantial obstacle. Like Casey, Carhart made bold assertions without statistical support and even acknowledged doing so. While we find no reliable data to measure the phenomenon, it seems unexceptionable to conclude some women come to regret their choice to abort the infant life they once created and sustained. Severe depression and loss of esteem can follow. It is alarming that the mere possibility that some individuals might regret an act can be part of the government's justification for criminalizing it. It is unexceptionable to conclude that some people regret getting married or divorced, but no one would argue that this is a reason for either to be criminalized. Both because the proportion of regretful people is presumably small, and because people have a fundamental right to control their family lives, even where they may come to regret their decisions. Both reasons apply equally well to abortion. Even more alarming, germane to informed consent, the court found another justification for the ban in the following string of possibilities. Doctors might not describe the details of the procedure in question to their patients. Some patients might later learn of those details, and some of those patients might experience serious grief and sorrow. The last step in this imagined scenario, that a woman who regrets her abortion must face deeper grief and sorrow when she discovers the detail of the procedure, was characterized as self-evident by the court. Even though it is an empirical proposition that demands supporting evidence like any other claim about human psychology. Bafflingly, the Carhart court used an informed consent justification to uphold not a requirement of robust disclosures, but a criminal ban on a safe procedure. This ban restricts patients' autonomy rather than protecting it. As Justice Ginsburg put in her dissent, eliminating or reducing women's reproductive choices is manifestly not a means of protecting them. The court's mistaken strategy of using the idea of informed consent to justify regulation that does nothing to protect the values that informed consent serves, the provision of information, and the enabling of autonomous choice. Rather, the anti-abortion strategy uses informed consent as an obstacle to abortion access. These examples show the court's willingness to accept the notion that women's decision-making abilities are deficient, which is supposed to justify forcing women to receive certain information, to endure mandatory waiting periods, and to have some options taken away from them altogether. Unsupported assumptions about further regret become reasons to restrict women's actions, despite the fact that various life choices people make become a source of regret. may become a source of regret. The power of self-determination, that principles of liberty grant to individuals, entails a requirement that individuals face the consequences of their actions. Informed consent, a doctrine designed to facilitate self-determination through the provision of the information needed to make a decision, is manipulated in the service of the political goal of restricting abortion. That this is the political goal of biased counseling statutes will become clear as Part 2 describes these statutes and explains the ways they are intended to discourage abortions. Legislatures have been encouraged by the fact that the Supreme Court upheld Pennsylvania's biased counseling in Casey, as well as the mistrust of women apparent in the court's decisions, to enact biased counseling laws that go far beyond the Pennsylvania statute that was before the court in 1992. Biased counseling laws. Over half of the states have laws that specifically regulate the informed consent process for abortion, placing requirements on providers and patients that are more demanding than for any other medical procedure. These laws are intended to discourage women from choosing to terminate their pregnancies. Part 2 discusses examples of the most troubling features of these laws. They intend to discourage abortions, reveal disdain for women's decision-making, and are based on false views of the medical facts. Part 3 will argue that these characteristics of biased counseling laws violate medical ethics. False or misleading statements about risks. Several states' biased counseling laws require that healthcare providers make statements to patients about specific risks, such as infertility or psychological problems, in order to properly inform the patient's consent. Some of these risk statements are exaggerated, misleading, or simply false. Statutes in several states require abortion patients to be told of a risk of infertility. However, some states do not include qualifications about medical accuracy or specificity regarding the patient's procedure. The Texas Counseling Booklet for Patients states that complications of abortion may make it difficult or impossible to become pregnant in the future or carry a pregnancy to term. State-produced materials that must be offered to patients in South Dakota state that infertility is a risk of abortion, without any qualification. However, studies have found that there is no association between induced abortion and later infertility. The most common first trimester abortion method, vacuum aspiration, poses virtually no long-term risk of infertility, ectopic pregnancy, spontaneous abortion, or congenital malformation. Some complications of abortion may implicate future reproduction, but complications are rare. Many states' laws require healthcare providers to tell patients about the emotional or psychological consequences of having an abortion. Several states' biased counseling materials note that women who obtain abortions may feel a range of emotions, from sadness to relief, a statement that is of course trivially true of many significant life events. These laws require doctors to tell all of their patients that competent adults, there may be emotional consequences to the decision to terminate their pregnancies. Anti-abortion legislators believe that women need to be told this because they likely espouse an unjustifiable skepticism about women's moral reasoning and decision-making abilities. Some states' biased counseling laws and materials claim that abortion can result in specific negative emotions and serious psychological problems. In Michigan, the counseling materials that must be given to every patient are required by statute to state that as the result of an abortion, some women may experience depression, feelings of guilt, sleep disturbance, loss of interest in life or sex or anger. In West Virginia, counseling materials that must be offered to abortion patients state that many women suffer from post-traumatic stress disorder syndrome following abortion, PTSD is a psychological dysfunction resulting from a traumatic experience. The materials provide a long list of symptoms that includes depression, drug abuse, eating disorders, chronic relationship problems, and suicidal thoughts or acts. Among other things, South Dakota's bias counseling statute required that abortion patients be told about the known medical risks of abortion, including an increased risk of suicide, ideation, and suicide. But that requirement has been struck down because they are not known risks of abortion. In addition, some states' counseling materials mention psychological risks, even when they are not required to by statute. Best scientific evidence shows that there is no causal relationship between abortion and psychological problems. Many studies to the contrary have been found to have methodological problems. There is an association between abortion and mental health problems, but study shows that the association is due to common causal factors. That is, factors that place women at higher risk of mental problems also increase the risk that they will experience unwanted pregnancies and obtain abortions. This association is not evidence that having an abortion causes later psychological problems, but rather that both are caused by previously existing factors. In sum, the most powerful predictor of a woman's mental state after an abortion is her mental state before the abortion. In addition, women who seek abortions are by definition experiencing an unwanted pregnancy, which is itself a stressful circumstance that may exacerbate psychological problems. What is more, the warnings in bias counseling statutes are not accompanied by similar warnings about the mental health consequences of childbirth, such as postpartum depression, which poses a significant risk. Studies show that becoming a parent can increase the risk of depression and other mental health problems. While it is true that some women experience negative emotional responses to their abortions, this is also true of many medical interventions and other types of life events. However, the laws surveyed above exaggerate the likelihood and severity of risk. The putative patient-protected benefit of these laws is premised on the idea that women cannot predict their feelings after abortion and need to be informed that they may suffer negative emotional consequences. By focusing on negative psychological risks, these laws attempt to use fear to discourage women from terminating their pregnancies. Number 3, breast cancer. In a handful of states, statutes require that patients be told that having an abortion increases their risk of breast cancer when it is medically accurate. In Alaska, Oklahoma, and Texas, state-produced materials that must be either given or offered to abortion patients claim that there is a possible link between abortion and breast cancer. In 2011, North Dakota added a statutory requirement that its counseling materials discuss the possible increased risk of breast cancer. While scientific studies have produced inconsistent results as to whether abortion increases the risk of breast cancer, the methodology in many of the studies that apparently show a link has been criticized. These studies use small sample sizes, collected data from subjects after breast cancer had been diagnosed, and relied on self-reporting of abortions. Better designed studies and meta-analysis have collected data on tens of thousands of subjects and relied on medical records rather than potentially unreliable disclosures by patients about their abortion history. In recent years, study after study has established that there is no link. The laws mentioned above allow providers to refrain from making a statement to the effect that abortion increases the risk for breast cancer because the statement is not medically accurate. However, the inclusion of inaccurate statements in state-produced counseling materials that providers are required to give or offer to patients is concerning, as some patients may understand the statement to be endorsed by the healthcare provider who actually gives them the material. B. Irrelevant or immaterial information. Several states require that women be given state-published counseling materials prior to an abortion. Materials that contain information that is irrelevant or immaterial to the decisions before the abortion patient. For example, Idaho's statute requires women be given materials that describe and display photographs of the characteristics of the embryo or fetus at 2-week intervals from the 4th to the 24th week of gestation, as well as descriptions of the abortion procedures used in current medical practices at the various stages of growth of the fetus, and any reasonable foreseeable complications and risks to the mother. Thus, for example, a patient who at 7 weeks seeks a medical abortion, which involves no surgery, must be given information about the characteristics of fetuses at much larger stages of development. In addition, she is given information about surgical abortion procedures used only at the later stages of pregnancy, information that bears no relevance to her medical situation. Even the portion of the material that describes the procedure the patient will receive does not necessarily limit itself to relevant information. Not every detail of a surgical procedure is helpful to patients in their decision-making. No law requires that heart surgery patients be told what will happen to their bodies in graphic detail. The fact that the average person would be disgusted and disturbed by a detailed description of a heart surgery does not warrant requiring such a description as a condition of effective consent. On the contrary, most patients would likely rather not hear the description because it would only increase their anxiety about a procedure they must undergo. Those patients who want a detailed description can always communicate that information is material to their consent by asking the doctor for a description. Similarly, even accurate pictures and descriptions of an embryo or fetus at the same stage as the patient's pregnancy are not necessarily relevant to patients' informed consent. Informed consent disclosures are intended to convey medical risks and benefits. Pictures and descriptions of embryos and fetuses are included in counseling materials because they are assumed to have an emotional or moral content. C. Statements about fetal pain. Recent years have seen a trend towards states including claims about fetal pain in their biased counseling requirements. For example, in 2010, Missouri added a provision to its biased counseling law that requires doctors to provide patients whose pregnancies are at 22 weeks of gestational age or further with materials that offer information on the possibility of the abortion causing pain to the unborn child. There is no when medically accurate qualifier. The following statements are required. At least by 22 weeks of gestational age, the unborn child possesses all of the anatomical structures, including pain receptors, spinal cord, nerve tracts, thalamus, and cortex that are necessary in order to feel pain. A description of the abortion procedure to be performed and the elements that could be painful to the unborn child. Fetuses at 22 weeks gestational age and beyond seek to evade certain stimuli in a manner that an infant or adult would be interpreted as a response to pain. Anesthesia is given to fetuses at 22 weeks or more during prenatal surgery, and anesthesia is given to premature babies at 22 weeks or later. Anesthesia is available in order to minimize or alleviate the pain to the unborn child. In 2011, Indiana enacted a statute regulating the provision of abortion in several ways. One new requirement was that the abortion providers must inform all abortion patients, orally and in writing, that objective scientific information shows that a fetus can feel pain at or before 20 weeks of post-fertilization age. The law requires that this statement be made to all abortion patients, regardless of whether their pregnancy has progressed to 20 weeks or not. The Texas Counseling Booklet states that the 12th week of gestation, the fibers that carry pain to the brain are developed. However, it is unknown if the unborn child is able to experience sensations such as pain. South Dakota counseling materials state that findings from some studies suggest that the unborn fetus may feel physical pain. without limiting the claim to a particular gestational age. These fatal pain statements are misleading. They are designed to make patients think that it is likely that a fetus of a certain gestational age can feel pain in circumstances when in fact the scientific evidence does not support that proposition. For example, biased counseling materials that mention fetal pain frequently make the claim that fetuses at some stage of gestation, often 20 weeks, have the necessary physical structures to feel pain. There is scientific evidence that the neural pathways that are necessary for pain perception form as early as the 20th week of gestation, although other studies place this development later, between 23 and 30 weeks. But even if the structures are in place at 20 weeks, that does not necessarily mean they are functioning at that time. Lungs, for example, are physically formed before they function. One review of scientific studies found that the arrival of sensory impulses in the brain could not be detected before 29 weeks. Furthermore, there is data suggesting that fetuses are in a constant sleep-like state and unable to experience pain, and that biochemicals in the in utero environment may sedate and anesthetize the fetus. Similarly, many experts believe that fetal reactions to tactile stimuli are reflexes that do not indicate a sensation of pain. Such reflexes are exhibited in humans who have no forebrain due to anencephaly or whose cortex is not functioning. Since most experts believe the cortex is necessary for awareness of pain, the presence of reflexes in individuals without functioning cortexes is evidence that those reflexes are not necessarily indicative of the sensation of pain. Fetal anesthesia and analgesics serve purposes other than pain reduction, such as inhibiting fetal movement and preventing hormonal stress responses. Their use in surgery is not evidence that surgeons believe that fetuses feel pain. Although any reader not familiar with the science behind the practice of fetal surgery would take the statements in the counseling materials as evidence that doctors believe fetuses feel pain. While there is a controversy among experts regarding fetal pain past 20 weeks, the statements made in some states' counseling materials do not notify patients of the controversy. They either articulate only one side of the controversy or selectively refer to certain facts without adequately explaining their implications for the possibility of fetal pain. South Dakota's complete lack of qualification of the statement that the unborn fetus may feel physical pain makes it misleading to the point of falsehood, since it is uncontroversial that embryos and fetuses early in gestation cannot feel pain. The Texas booklets claim that it is unknown whether fetuses can feel pain at 12 weeks is equally misleading, since there is not scientific debate about the fetal pain that early.
May I inquire of my fellow Missouri?
Yes, I yield to my fellow Missourian.
My name is Carolyn Noga, and I'm a retired teacher from Reed Spring, Missouri. I taught 24 years at the GoTech in Reed Spring. And I'm participating in the Women's Filibuster, which began on Monday, May 12th at 2 p.m. and is being held for 72 hours until Thursday, May 15th at 2 p.m. I'm here today because, I'm sorry. Okay. You can tell I'm very technologically inclined here. I'm here today because our elected representatives in the state of Missouri have spent time and money coming up with 32 bills that deal with women's lady parts. The ladies' personal parts, private parts. And I do feel that they could probably spend their time a whole lot more efficiently, cheaply. We have bridges that are falling down. We have schools that aren't fully funded. There's lots of good things that they could be doing besides worrying about how many times that people or the ladies in Missouri are having sex or needing health care. This session, politicians in Jefferson City have spent countless hours advancing more than 30 bills that are hostile to women's health, including a dangerous bill that would triple the state's mandatory waiting period for a woman seeking a safe and legal abortion, and that's the only one they have actually gotten to the governor's desk, and we're all hoping that he'll veto it. This bill is part of an intrusive agenda to undermine women's health and would create another barrier in this state in accessing a safe and legal abortion. Lawmakers should be trying to improve health outcomes in Missouri, not further restrict. Today I'll be reading from the Michigan Journal of Gender and Law. While there is a controversy among experts regarding fetal pain past 20 weeks, the state remains some states counseling materials do not notify patients of the controversy. They either articulate only one side of the controversy or selectively refer to certain facts without adequately explaining their implications for the possibility of fetal pain. South Dakota's complete lack of qualification of the statement that the unborn fetus may feel physical pain makes it misleading to the point of falsehood, since it is uncontroversial that embryos and fetuses early in gestation cannot feel pain. The Texas booklets claim that it is unknown whether fetal pain at 12 weeks is equally misleading, since there is not even scientific debate about fetal pain that early. Furthermore, while some statutes require that women be notified of the option of fetal anesthesia, they do not require disclosure of the risk that fetal anesthesia carries for pregnant women. Yet again, the bias in favor of childbirth in these laws is clear. There is no real effort to give patients all of the information that might inform their choice. Legislators bend over backward to include anything that might discourage a woman from choosing abortion, but omit corresponding risk on the other side of the scale. And waiting 72 hours is not going to change a woman's mind. Since 2005, South Dakota's bias counseling statute has required that the physicians tell their abortion patients that the abortion will terminate the life of a whole, separate, unique, living human being. In 2009, North Dakota added an identical mandatory disclosure. Some bias counseling laws convey ideological speech in slightly more subtle ways. Bias counseling materials frequently use anti-abortion language, especially by referring to the pregnancy as an unborn child. Some states produce materials to direct patients to crisis pregnancy centers that are devoted to persuading women not to have abortions. Like, we're going to run out of a whole bunch of